with reference of the health condition of the applied mother and adjourn this matter on the of the more than 6. And the criminal appeal melody, both husband and wife melody, convicted melody. Husband was admitted in SCB for open heart surgery melody. Entry mail file for wife. Appeal was in appeal is in custody 7 years and 2 co-given. Blood affiliate is inside the custody for more than 12 years. Petition is in custody since 4 years. Court is for please give it.
2019 old matter order against cat. I've given several matters.
No.
Custody since 80.
Listing of two contempt petitions. My lord, we recollect passed an order in respect to that IAS promotion case. The UTSC were supposed to comply with my lord's order by the 10th of December. It's been 2 months, no compliance, no SLP listing. So I
Let me my case was before my on 18th of December. Adjourn to be taken out 2 weeks commence 20th January. Not listed.
Custody for 8 years.
Rehabilitation assistant mathematics for final year in science.
Supplemental list. Item number 1.
Application for amendment 1376 IA. The last occasion my lord has directed with sharp copies. Have sharp copies. I have sharp copies to the Union of India as well as Ms. Ramita Plus.
Yes, Mr. Pari.
Lordship, I am appearing.
See, Mr. Milan is appearing this. So, anything you want to say on this? Interim application on for judging file for amendment. He wants to insert some paragraphs as for the schedule of proposed amendment. So, any objection to that or?
You're appearing for the Union of India.
Yes,
have you gone through the brief?
Yes, Lordship, but I have not received the IA copy of the IA.
It's since 28/1/24.
This is to the NHA.
NHA and it is filed in count. Receipt is filed.
Bring that. We'll take up this matter tomorrow.
Yes, sir.
And see whether you want to say something or we'll allow the IA.
Yes, sir.
For amendment. All right.
Yes, Lordship.
What is your name?
Milan Kumar, Your Lordship.
Milan Kumar, you are the
CGC. Yes.
Mr. Pari, along with so Mr. Milan Kumar submits that the matter may be taken up tomorrow to have their say on the interim application which has been filed for amendment with the petition. This matter tomorrow. Yes.
Item 2.
Department of Railways.
Be a little louder. You are challenging
Yes, ma'am.
the order under Annexure 21.
21. Relevant person manual dot 122. Page 122, paragraph 14. Present issue was considered by the Central Administrative Tribunal Principal Bench, New Delhi, in OA number 896/2007, judgment dated 28/1/2014. As observed by the Central Administrative Tribunal Principal Bench, New Delhi, in OA number 7, judgment dated at paragraph 22 at page 17. In view of the same, Railway Authority initiation of disciplinary proceeding prior to without establishing subletting of water without giving opportunity to refute the allegations against him as required under principle of natural justice and arriving at the conclusion on the basis of inquiry.
It is that case when you
Yes,
say
yes,
that you
yes.
visited
Right.
your authority,
Yes, three dates.
visited one day and found that somebody was
Right.
there,
Right.
and that is how you said that it has been sublet.
Sublet.
So we put a question that
Right.
suppose on a particular day
Right.
the concerned employee is not there and somebody is present there,
Right.
can that be a ground to say that it has been sublet, or for that you have to prima facie bring something more? Uh,
Here,
you have not examined that person
yes.
who was staying there,
No,
You-
that person has not been
right?
examined.
That the disciplinary proceeding re taku examine karani, not even the persons who are
No,
staying in
nobody
the
has been
neighborhood.
examined. That is the instruction.
So, on that basis, how can you say that?
And that is
Yes,
not there. That is there. Not there. Only some of the official witness has been examined.
No, no, official witnesses
Yes,
might have
non-elected
stated
witness has been examined.
only, and what happened to that person by way of passing this, which you have passed, that has been, of course, vast. What punishment you have imposed on him?
Punishment, my lord, also kindly have a glance to page. Two, deduction of pay in existing pay to be so and so on one stage below 20,000 for a period of 4 years.
So, several houses were verified on 3 dates,
Right.
as it appears from paragraph 2, page number 104 of the order, on 27, 29, and 3, 7, 2015. So, so far as the house of this opposite party is concerned, when the joint verification was made,
That is also
Up-
that is also they have not given on one day. They have not given specific date.
ଆରେ ଆପଣ ଏଇ 3ଟା ଡେଟ୍ରେ ଆପଣ କହିଲେ ପୁରା 100ଟା ଖଣ୍ଡେ କ୍ୱାର୍ଟର ଆପଣ
11ଟା quarter.
11ଟା କ୍ୱାର୍ଟର ତାଙ୍କୁ ଆ କ୍ୱାର୍ଟରଟା କୋଉ ଦିନ ଯାଇଛି
Specific date they have not.
ଆଉ ତାହେଲେ କେମିତି?
That is there. That lacuna is there, man. And you'll also kindly have a glance to page 120. There, rule 15A clearly provides that is also there. That is against the department.
What does it say?
That is said as Lordship from 15A says 15A CCA conduct rules bold 120 page 120 bold man. The respondent railway has initiated issued instructions in this regard by letter number
On 121,
120 man.
120. Just a minute.
Rule
Here.
15A of CCA conduct rule 1964 which reads as follows. Save as otherwise provided in any other law for the time being in force, no government servant shall sublet, lease or otherwise allow occupation by any other person of government accommodation which has been allotted to him. A government servant shall, after the cancel of his allotment of government accommodation, vacate same within the time limit prescribed by the allotting authority. Thereafter, my lord, the respondent railway has issued instructions. Next paragraph: subletting of government accommodation by railway employees. Departmental action against. Rule 15A of the Railway Service Conduct Rule 1966 provides that save has otherwise provided any other law of the time being potential servants lease or otherwise allow occupation by any other person of government accommodation which has been allotted to him. It has been decided that as soon as the charge of subletting is established by the pool holder, the allotment of quarter will be cancelled and the disciplinary authority shall initiate disciplinary proceeding against the railway servant concerned. In such cases, the competent authority suspension also, it may also please be ensured that charge sheets are issued immediately in cases where employees are likely to retire shortly or where they have already retired. Since such cases are likely to become time barred for initiation of department disciplinary proceedings by virtue of the misconduct being more than 4 years old. Next paragraph is against the railway department, page 121. From the aforesaid instruction issued by the DOPT and the railway, it is seen that the disciplinary proceeding on account of subletting can be initiated only after the allotment is cancelled, after allegation of subletting has been proved. Before such subletting is confirmed, the allotee of the government accommodation is required to be given as opportunity to rebut the allegation against him. In other words, an authority competent to cancel the allotment on the ground of subletting shall first of all cancel the accommodation in the name of the allottee after following a procedure in consonance with the principle of natural justice. It is only after the allotment is cancelled on account of proved subletting the disciplinary authority can initiate any inquiry proceeding. An inquiry by an official or committee of officials held behind the back of the allottee cannot be a ground for coming to the conclusion that the accommodation has been subletted. Before any such finding, the allotee should be put to notice and its representation should be considered. Here, notice has been given. Notice has been given. But so far as rebuttal is concerned, that is.
So why are you saying that it is against the department?
Maybe the other procedure that has not been.
So what procedure has not been followed according to you?
That cancellation.
Before initiation of departmental proceeding, the accommodation has not been cancelled. Agar cancel hoga तापर जाएगी departmental.
Cancel है नहीं, she is continuing there.
They are disciplinary proceeding initiated, thereafter cancelled.
No, but that has been set aside.
नहीं set aside. She is a challenge question. This product.
And that has been confirmed in appeal and revision.
That has been set aside.
And that has been set aside by the trial.
This writ petition has been filed. Union of India and others challenging the order dated 8/1/2024 passed by the London Central Administrative Tribunal, Cutter Bench in OA number 99 of 2017. In allowing the OA and setting aside the proceeding instituted against the opposite party Srimati in money by charge memorandum dated 21/8/2015 and also the punishment order dated 28/1/2016 and the subsequent orders of the appellate and review authorities dated 9/5/2016 and 7/9/2017 respectively. The opposite party filed the original application before the London Central Administrative Tribunal, Cutter Bench, under Section 19 of the Administrative Tribunal Act, with a prayer for declaration that the initiation of the proceeding by charge sheet under Annexure 3 and punishment order by Annexure 8 and the appellate order confirming the punishment and revisional order dated 7/9/2017 of the Chief Personnel Officer Bhubaneswar are without jurisdiction and for quashing the same. From the factual scenario, it appears that the opposite party was allotted a type 2 quarter bearing number 592/1 with effect from 23/12/2005 while he was working as office superintendent, public control office under senior DOM bracket RAM Valtier. Stop. A surprise door-to-door joint verification by the nominated committee was conducted on 3 dates, that is on 27/6/2015, 29/6/2015, and 3/7/2015 at the jail area of Visakhapatnam. And it was found that the allotted quarter of the opposite party was under unauthorized occupation and it has been subletted. Basing on such a fact-finding report of the committee, the senior divisional engineer by later dated 8/7/2015 recommended for taking action against the opposite party. By later dated 6/8/2015, the chairman so instructed the divisional personnel officer, East Coast Railways Valtier, to cancel the allotment of the quarters, initiate eviction proceeding, and recover penal rent from the opposite party. And consequently, the opposite party was issued with major penalty charge sheet under Section 9 of the Railway Servant bracket Discipline and Appeal Rules 1968 by memorandum dated 21/8/2015 by the senior divisional so-and-so manager, East Coast Railway Valtier, with a direction to submit the written statement of defense. Stop. The opposite party was also duly served with article of charges, statement of imputation, list of documents and witnesses to be relied upon. After receipt of such documents, including the articles of charges, the opposite party submitted her explanation in which she denied the allegation and considering the explanation of the opposite party, the disciplinary authority, in exercise of the power under Rule 9(2) of the rules, appointed an inquiry officer to inquire into the charges against the opposite party. The inquiry officer conducted the inquiry and the senior divisional transfer manager issued notice enclosing the inquiry and submitted the inquiry report. Issued notice enclosing the inquiry report to the opposite party to submit or reply of the representation, and the opposite party submitted her detailed reply to the so cause, stating that the inquiry officer did not consider the facts precipitated during course of inquiry, but mechanically held that the charges have been proved. The inquiry officer, instead of basing his conclusion on material evidence and facts, came to hold that charges seems to be proved, which shows that the inquiry officer acted in a preconceived opinion to conclude the charges as proved. There is it is further stated in the reply that there is no photo or videos to prove the subletting aspect, and major penalty charge sheet was issued without verifying the prima facie evidence and records. Which is in violation of Rule 9 of D and A rules. And the same is bad in law. It is further stated that the inquiry officer, by ignoring the statements of the opposite party, that the lady who was there on that day was her aunt, who had come for treatment at Apollo Hospital, has based his finding against the petitioner uh, against the opposite party. It is further stated by the opposite party that she was residing in the allotted quarters and produced the railway ID and Aadhaar card, clearly showing that the residential address is the railway allotted quarter. The notice was issued from the side of the petitioners. Counter affidavit was filed. Wherein it is stated that the orders passed by the disciplinary authority, appellate authority, and revisional authorities are based on available material on record, justifying the conclusion reached by those authorities. And the punishment imposed on the opposite party is commensurate with the charge leveled against her, and therefore no interference is required. It is further stated that the impugned orders were passed by the competent authorities by observing principles of natural justice, and there are no procedural irregularities. There is no flaw in the initiation of the disciplinary proceeding against the opposite party, and the departmental inquiry was just fair and held in a transparent manner in due obedience to the procedure enumerated in the Railway Servant T&A Rules 1968. The opposite party filed the rejoinder affidavit wherein he has relied upon some instructions issued by the railways relating to the procedure of departmental action, which is initiated on the acquisition of subletting of government accommodation by railways employees. In the instruction dated 19/6/1998, while referring to Rule 15A of the Railway Service Conduct Rules 1966, it is stated that disciplinary proceeding on account of subletting can be initiated only after the allotment is cancelled, after the allegation of subletting has been stopped. Before such subletting is confirmed, the allottee of the government accommodation is required to be given an opportunity to rebut the allegation against him. In other words, an authority competent to cancel allotment on the ground of subletting shall first of all cancel accommodation in the name of the allottee after following a procedure in consonance with the principle of natural justice. Stop. It is only after the allotment is cancelled on account of proved subletting, the disciplinary authority can initiate any inquiry proceeding. Stop. It is further stated that an inquiry by an official or committee of officials held behind the back of the allottee cannot be a ground for coming to the conclusion that the accommodation has been subletted. And before any such finding, the allottee should be put to notice and his representation should be considered. The London Central Administrative Tribunal, after hearing the London Council for both the parties and perusing the relevant records and documents, came to hold that so far as Rule 15A of 1966 rules is concerned, the same deals with subletting and vacation of government accommodation, wherein it is clearly stated that no railway servant shall sublet, lease, or otherwise allow occupation by any other person of government accommodation which has been allotted to him. In the London Tribunal has also referring to the instruction dated 19/6/1998 of the railways on this issue held that as soon as the charge of subletting is established by a pool holder, the allotment of quarter will be cancelled and the disciplinary authority shall initiate the disciplinary proceeding against the railway servant concerned. The learning tribunal has been pleased to hold that the railway authority, that is the initiation of disciplinary proceeding prior to without establishing subletting of quarter, without giving opportunity to rebut the allegation against him, as required under principle of natural justice, and arriving at the conclusion on the basis of inquiry conducted by the committee of the official behind the back of all, and the accommodation has been subletted, etc., are all contrary to rules and to their own circular. Accordingly, the learned tribunal has been pleased to pass the impugned order. The Land Council for the Union of India, after arguing for some time, fairly submits that the Learning Tribunal is right in holding that the due procedure which has been uh, formulated in the instruction relating to subletting initiation of the proceeding in case of acquisition allegation of subletting of government accommodation by the uh, railway employees has not been followed properly in this case. After going through the documents which are annexed to the writ petition, and more particularly the explanation submitted by the opposite party, and the evidence adduced during course of inquiry, and the inquiry report, we are also of the view that there is no flaw in the impugned order passed by the London Central Administrative Tribunal. Therefore, we are not inclined to interfere with the impugned order. Accordingly, the writ petition stands dismissed. It is, however, open to the petitioner to initiate the proceeding afresh in accordance with law if it is so advised. Yes.
Item 3.
Please alert me. Item 3, I'm appearing on behalf of the Union of India for all the petitioners. This is a writ petition challenging the learned Central Administrative Tribunal's order dated 12/7/2022 in OA number 279 of 2022, Your Lordships. This is regarding regularization of leaves of the opposite party. The period at which the opposite party was serving as a senior field officer in ARC Charbatia, his leaves were supposed to end on 15/3/2020. 3 days after which he called telephonically to his controlling officer and asked for an extension for leave. To that effect, Your Lordships, I may draw Your Lordship's attention to page 15, which is Annexure 1, and then page 18, Annexure 2.
What is the period he has overstayed?
5 months. He subsequently joined in August.
So what ground he has taken?
The ground is that he had called telephonically and asked for extension of leave. To which my answer is at page 18, Annexure 2, Your Lordships. It's a very, very clear circular regarding how you can ask for leaves on telephonic extensions.
No, it is the period of that lockdown on account.
Lockdown. But his leave was supposed to end before the lockdown was announced. That is how specific the office
date?
memorandum is.
What date?
18th his leave was supposed to end. He was
18th of
March.
Oh,
If I remember correctly, Odisha had
Yes.
3 days lockdown before the national lockdown. Odisha had declared lockdown. I may be mistaken, but as far as I
Janta
remember,
lockdown was on 22nd. Your Lordships is correct. And the national lockdown was announced on 24th March. So the office memorandum, if I draw Your Lordship's
Council, you should just visualize the situation even prior to the lockdown in this news and all these things. There was it was sprayed that how the days are taking place and what is the condition in different. So that may be the ground for which she might have felt panic, and thereafter the lockdown there is no problem. So even if he at that point of time there was some delay, you cannot take the entire period. But you say that he was supposed to join on
18th March. He called telephonically. His leave was supposed to end on 15th March, Your Lordships. Page 4. Para 3 of
No,
the
you see, come to paragraph number 2.
2.
Please place that.
Para 2 of the writ petition. Your
No,
Lordship.
no, of the impugned order.
Right.
Page 21.
Yes. The brief of the case as entirely averred by learned counsel for the applicant is that the applicant who is working as senior field officer in the respondent department went on sanctioned earned leave with effect from 2nd March to 13th March 2020. And before expiry of the said leave, he had approached the concerned authority seeking extension of leave period from 18th March to 27th March. And the same was also sanctioned by the authorities. The applicant was supposed to join his duty on 30th March. So we are contending that the second leave that he approached, he called telephonically, and that is not a sanctioned leave.
Just read that.
But due to lockdown imposed all over India due to COVID-19 pandemic situation, no transportation was available for him to travel to his place of duty, that is Charbatia. The applicant submitted that after situation became normal and he was trying to join due to ill health and hospitalization of his father, he returned to his workplace on 17/8/2020 and joined with effect from 31/8/2020 after remaining in home quarantine.
What is your case?
My case is that his subsequent, Your Lordships, if Your Lordships sees, he says that applicant was supposed to join his duty on 30th March 2020.
Come to the finding of the learning tribunal.
I think it's page
Page
24.
Paragraph 7 you come. Paragraph 7 at
Page 23.
Yes.
Admittedly, the applicant was sanctioned EL on first instance, that is from 2nd of March 2020 to 13th March 2020. Thereafter, he applied for extension of leave from 18 March 2020 to 27th March 2020, which was also sanctioned. It is for the nationwide lockdown due to COVID-19 pandemic situation. The applicant would have joined on 30th March. Learned counsel for the applicant submitted that in view of the DOPT office memorandum dated at clause 4, the applicant should have been treated to be on duty with effect from 25th March and the period from 25th March 2020 to
1st of June 2020 should be dealt accordingly. We are not in agreement with the same since column 4 deals with those who have requested for curtailment of leave period, and it is for the authorities to decide on the curtailment, which is to be done on rare cases. It is also not known if the applicant had applied for the said curtailment. But our case is not on clause 4, Your Lordship,
Yes,
for the curtailment.
come, next paragraph.
Para 8. The DOPT Office Memorandum dated 28/7/2020 was issued to remove the constraints faced by employees who were on tour, leave, etc., and got stuck at a location without having access to transportation to join at the duty place. It is very clear on how to deal with the various situations faced by the government employees who were affected due to the lockdown. As per column number 2 of the notification, those employees who were on leave prior to notification of lockdown and their leave ended during lockdown period, they should be deemed to have joined duty on the date their leave expired. And if intimation in any form indicating difficulty in joining duty due to non-availability of public transport or flights has been given by the government servant to the office, in the present case, the sanctioned leave of the applicant was to end on 27th March. Therefore, he should be treated on duty from 28th March, 28th and 29th March being Saturday and Sunday. Accordingly, this OA is disposed of with above observation and direction to the respondents to consider the case of the applicant and sanction the leave of the applicant from the period 28th March to 1st 6 2020 strictly in terms of DOPT Office Memorandum dated 28/7/2020 column number 2, and the rest period of leave from 2nd June 2020 to 17/8/2020 be sanctioned as per rules.
Yes, so what is the illegality in that?
I mean, draw your lordship's attention to the dates. The dates are very specific here, your lordship. Your lordship may come to page 4, para 3. He was sanctioned leave from 2nd March to 13th March, which was calculated as 29th February to 15th March, including Saturday and Sunday. So he was supposed to join on 16th March. The lockdown period had not started by the 16th of March, your lordships. On 18th March, the OP informed telephonically to his controlling officer for extension of leave on domestic ground. My entire case lies in these two sentences, your lordships. I may draw your lordship's attention to page 15 now, annexure 1. The second para in the column, the second part, clause 2. Government servants who are on leave prior to issue of lockdown orders with effect from 25/3/2020 and the leave ended during lockdown period. The clarification is deemed to have joined duty from the date of expiry of leave. If intimation in any form indicating difficulty in joining duty due to non-availability of public transport or flights has been given by the government servant to the office, in case of leave on medical grounds, this is subject to the production of medical or fitness certificate. My case is on clause number 2 and not on clause number 4 as stated in the judgment. Clause 4 is regarding government servants who ask for curtailment of the leave. My case is not that. My case is clause number 2, which I read to your lordships. His leave ended before 25th of March. Then I may draw your lordship's attention to the circular, which is at annexure 2, page 18, which will amply clarify my stance. Para 3 of the circular, your lordship's at page at annexure 2. Para 3, it says, this may be impressed upon the concern that extension of leave already granted without the sanction of competent authority or without an emergency ground will be viewed seriously hereinafter. Further, the intimation regarding leave or extension of leave must be mentioned with tentative period and ground of leave, or its extension without such intimation holds no validity. All unit heads may thereafter please take care to ascertain from the telephonic intimation from the caller the tentative period and ground of leave, extension of leave while sending intimation to the office.
Telephonic intimation is not totally prohibited.
Is not totally prohibited. Had he mentioned the reason
So
and the tentative
that is his
period.
case that I have given the telephonic intimation, and how do you say that that was an unauthorized one? He said that you come to that. That is his case also.
That is his case that he called telephonically
Yes.
after his leave period expired. That is the first point. And second, the tentative period and ground of leave was never ascertained, because by that also, if your lordship says 18th of March, still the lockdown had not started. And there was no suspension of flights or trains or any mode of transport before the lockdown started.
are the Land Council for the Union of India. In this writ petition, the petitioners, Union of India and others, are freed for passing the order dated 12/7/2022, passed by the London Central Administrative Tribunal, Qatar, in OA number 279 of 2022. It appears that the opposite party, Subhash Chandra, have you given that original application?
We have not done it.
No.
Copy that.
Filed the original application challenging the order of rejection dated 26/5/2022 for regularization of the leave during COVID-19 lockdown period. Inter alia with other players. The opposite party was working as senior field officer in the department. What is the department?
Aviation Research Center,
Research.
Charbatia.
Aviation Research Center, Charbatia. And he went on sanction on leave with effect from 2/3/2020 to 13/3/2020. And it is the case of the opposite party that before expiry of the said leave, he approached the concerned authorities seeking extension of the leave period from 18/3/2020 to 27/3/2020, which was sanctioned by the authority. And he was supposed to join his duty on 30/3/2020, bracketed 28th and 29th being Saturday and Sunday. But due to lockdown imposed all over India due to COVID-19 pandemic situation, no transportation was available for him to travel to his place of duty, that is Charbatia. And after the situation became normal, he fell ill and hospitalized. His father fell ill and was hospitalized, for which he returned to his duty on workplace on 17/8/2020 and joined on 31/8/2020 after remaining in home quarantine. The opposite party submitted the representation requesting the authorities to regularize the interregnum period during COVID-19 situation in accordance with the DOPT OM dated 28/7/2020. However, his representation was rejected by the respondent number 3. Who is respondent number 3?
Petitioner number 3.
Petitioner number 3. That is Secretariat PG bracketed S by order dated 24/9/2021 with a direction to the opposite party to submit leave application for the entire period starting from 2/3/2020 to 17/8/2020. Stop. Another representation which was filed on 18/2/2022 was also rejected by order dated 26/5/2020. It is the contention of the petitioner before the learning tribunal that the national lockdown was from 25/3/2020 and the rail/air services had resumed from 1/6/2020, but the opposite party did not join the duty even after resumption and joined only on 17/8/2020. Therefore, his request was not acceded to and he was asked to submit revised leave application. The learning tribunal took into account in detail the DOPTOM dated 28/7/2020 and came to hold that admittedly the applicant was sanctioned on leave at the first instance from 2/3/2020 to 13/3/2020 and thereafter he applied for extension of leave from 18/3/2020 to 17/3/2020, which was also sanctioned. If it was not for the national lockdown due to COVID-19 pandemic situation, the opposite party could have joined on 30/3/2020. The learning tribunal has been pleased to accept the contention raised by the learning council for the opposite party that in view of DOPTOM dated so and so at clause 4, the applicant, the opposite party should have been treated as on duty with effect from 25/3/2020 and the period from 25/3/2020 to 1/2020 should be dealt accordingly. The learning tribunal took into account the column 2 of the DOPT OM dated 28/7/2020, wherein it is stated that those employees who are on leave prior to the notification of lockdown and their leave ended during the lockdown period, they should be deemed to have joined the duty on the date their leave expired. If intimation in any form, indicating difficulty in joining duty due to non-availability of public transport oblique flights has been given by the government servant to the office. And in the case in hand, the sanctioned leave of the opposite party was to end on 27/3/2020. Therefore, he should be treated as on duty from 28/3/2020. the learned tribunal disposed of the original application and directed the petitioners to consider the case of the opposite party and sanction the leave for the period 28/3/2020 to 1/6/2020, strictly in terms of DOPT OM dated 28/7/2020, and the rest of period of leave, that is 2/6/2020 to 17/8/2020, we sanction as per rules. The learned tribunal also observed that the opposite party would also be entitled to any benefit arising out of the said regularization of service. During course of argument, the land counsel for the petitioner brought to the notice of this court the circular dated 17th June 2019, issued by the Assistant Director of Aviation Research Center, wherein it is stated that extension of leave already granted without the sanction of competent authority or without any emergency ground would be viewed seriously. The intimation regarding leave, public extension of leave, must be mentioned with tentative period and ground of leave and its extension, without which such intimation holds no validity. All unit heads were asked to ascertain from the telephonic intimation from the caller, the tentative period and the grounds of leave, public extension of leave, while sending intimation to this office. Therefore, this circular makes it very clear that on telephonic intimation, if extension of leave is sought for, the same can be granted. In the case in hand, it is the case of the opposite party that he applied for extension of leave from 18/3/2020 to 27/3/2020 over phone, and the same was sanctioned. Therefore, the learned tribunal is quite justified in holding that the case of the petitioner comes within column 2 of DOPT OM dated 28/7/2020. Stop. After hearing the learned counsel for the petitioners and going through the impugned order carefully, we find no flaw in the impugned order. Accordingly, the writ petition stands dismissed.
Item 4.
Obliged, ma'am.
Item 4, Practical directed to call for a report from the Tahsildar as well as the collector Sambalpur.
Please come to that order dated 27/1/2025. So 8/1/2025, prior to that, yes, 8/1/2025 is another order.
Yes.
Last two paragraph, my last, on the second page. The aforesaid OGLS miscase was treated in the year 2003. It was a very sorry state of affairs that in the meantime more than 21 years have elapsed, but till that no final decision has been taken on the said OGLS miscase. Let the report be confirmed from the collector Sambalpur as well as the additional Tahsildar Ratho Sambalpur as to why there was an inordinate delay in disposal of the OGLS miscase over circumstances. Where is that report?
Sorry. This is the report from the collector. Kindly grant me 2 days time so that I can get the report from the Tahsildar.
But I think there was another letter last date you had given, which is there on record.
It's on record. That's the 24/1 letter. 24/1 by the Tahsildar.
When it was disposed of?
No, it is pending here.
Pending or disposal?
It is pending here. Pending, they're taking steps for
No, then
comparison
your
between the HAL and subject.
earlier information was incorrect.
Kindly see the paragraph number 2 of that report. May I read?
ये जो आज जोटा दौचंती, it indicates that it is pending.
It is pending.
Which paragraph you have said?
Paragraph 2 here.
Paragraph 2.
Yes, may I read it? The report of the Tahsildar Sadar Sambalpur has replied by this letter number so that the matter is now pending at settlement officer Sambalpur to furnish HAL Sabi comparison statement along with the others copy in connection with the OGLS case number so from 5/1/24. They are taking steps against the officers who are responsible for the delay in disposal of the matter.
So this letter which you produced on that day, that is dated 24/1/2025.
Yes, sir.
That is letter at flag 20, wherein it is mentioned that the case is disposed of accordingly, is not a correct one. Upon flag 20 को आसंतु, letter flag 20. अपन से दिन लिखिथिले ये OGLS miscase number 29 of 2003
Has been disposed
गला एवं accordingly the case was disposed of.
also rejecting the prayer of the petitioner to settle the land.
So now you are saying that no, it is not disposed of, it is pending.
The report from the Tahsildar is awaited. Can I have
What do you mean report of the Tahsildar, letter of the Tahsildar? That is what we are asking. Is that incorrect?
I'll
Or you
take
have not gone through?
Well, I'll take instruction on this one.
Completely contradictory. You see, 24/1/2025 ର letter ଆଉ ଆଜିର ଯୋଉଟା produce କରୁଛନ୍ତି ଦିଟା ଯାକ ତହସିଲଦାର ର ଇଏ
Yes, sir.
ଏଇ report ଟା ଆପଣ କିଏ ଦେଇଛନ୍ତି?
ଏଇଟା ଆଜିର ଟା କଲେକ୍ଟର ଦେଇଛନ୍ତି ADM.
ଅଭିଷେକ 2022 ସେ ଗୋଟେ ରିପୋର୍ଟ ମଗେଇଥିଲେ, ସେ 22 ଦେଲେ ଯେ ଏଇଟା ପେଣ୍ଡିଂ ବିଲ୍. That the report of the Tahsildar reported at letter number so and so that the matter is now pending at the so and so to furnish so and so in connection with it. Eta journally enclosure.
So on 22/1/25 he reported that it is pending.
It is pending.
On 24 he reported that it is disposed of. So has he disposed of within 2 days?
No.
May not.
What pending which
The collector said it is still pending.
Collector कौन कहेगा तो तहसीलदार अगर pending है.
That is on the basis of the report by the Tahsildar.
Annexure 1.
No, for neglecting the message, but whether it is disposed of पहले, that means that statement is incorrect.
Maybe 24 on
This is incorrect.
Sorry?
With the 24/1/25 letter, maybe a miscommunication, I'll take exception on that.
Maybe means it can't be taken that lightly. How can he give incorrect
I'll-
information to the High Court?
Let's
Sign an
say
affidavit.
post this matter to Monday, I'll take exception.
Because every 2 days, if he takes contradictory stands, it will be difficult
I'm
to
confident.
decide.
File an affidavit that
I'll file it.
So at least the correct position will be there on record. He can also.
I'll file it.
Yes.
as per the order dated 27/1/2025, the Learning Council for the state has produced the later dated 3/2/2025 of the District Magistrate and Collector Sambal, wherein in paragraph number 2, it is stated as follows. Quote the entire paragraph. And in paragraph number 6, it is stated as follows. Paragraph number 6, quote. These two paragraphs of the later dated 3/2/2025 runs contrary to the later dated 4/1/2025, later dated 24/1/2025 of the Tahsildar Sadar Sambalpur, issued to the addressed to the Land and Additional Government Advocate.
My lord, sir. Because I was in fact on my books.
Yeah.
That letter will be recorded. That was what I was submitting earlier, which is why in fact, I am awaiting such instructions. They've already been given. I'm just getting.
No, record ମାନେ କଣ ମାନେ ଆପଣ ଗୋଟେ ଦେଲେ ସେଟା
My lord, what I was submitting last time was that was issued by mistake without understanding the implications of what is happening here. So my lord, that has been.
That is what we are saying. Let him give an affidavit
Okay.
explaining.
I have just received it.
Yes, that's all right.
I'll hand over.
I'll pass on for 24/1/2025, wherein it is mentioned that OGLS miscase number 29 of 2003 has already been disposed of.
They conducted an inquiry for all the officers who were dealing with those cases right from the year 2003. That list is in the second page of that instruction. 13 officers were there, out of which 3 have retired, 1, 2, 4, and the rest of the officers they have been issued so-called and begs apology, my lords. Somehow.
That is different. Dependency. We are about giving wrong information to the High Court.
By way of an affidavit, it should be said that
it has to be recorded. I'll do.
The Land Additional Government Advocate also produced the letter of the Tahsildar Sadar Sambal dated 3/2/2025, wherein he has begged apology for the inordinate delay in disposal of OGLS miscase number 29 of 2003 by his office, and has assured that all possible steps will be taken by this office to prevent such delays in future. And he has prayed for 45 days time for disposal of OGLS miscase subject to cooperation of the petitioner.
Not really, there was a wrong information. They should explain something. Take any action.
Land Council and Land Additional Government Advocate submits that he will file an affidavit of the Tahsildar Sadar Sambal that inadvertently the letter dated 24/1/2025 has been issued, has been addressed to the additional government advocate, and the same is to be not pressed. Put up this matter next week as well.
And the present status of that case.
Present status of pending to coinciding in time wise.
সেটা भी positive one.
इनका पैराग्राफ कोट कर दे तू ही हो छो है ना
अभी तो हम पेपर तो अच्छी है
Item 5.
Please, Your Lordship, my lord, as stated, my lord, I am filing one additional affidavit and the fresh synopsis as directed by Your Lordship.
problem.
My esteemed sister is right that it should be filed nowadays in view of this paperless code. Whatever document you want to file, you file there because
We can
now
peruse it,
you
but
can peruse it.
but otherwise we have to maintain another file here. We are supposed to be paperless. And manning kaun hella if all documents are filing here. Same with you. That is all right. You can bring to our notice, but file it there. We'll pass out accordingly. Same with you because file here. What do we do? We don't have a file here.
କାରଣ ଆପଣ ଏଇ ଯୋଉ previous case ଟାରେ ଦେଖନ୍ତୁ ଯଦି ଆପଣଙ୍କର version କୁ ଆପଣ accept କରିଦେଇକିନି ଆମେ କଣ କରିଥାନ୍ତୁ UGLS miss case dispose of ହେଇଯାଇଛି let him challenge that order before the appropriate forum. In fact ଯଦି ସେଦିନ dispose of କରିଦେଇଥାନ୍ତୁ ସେ କହିଲେ ଯେ ନାଇଁ ଆଜ୍ଞା the opportunity ଦିଆନି in fact dispose of ହେଇନି so we called for and now it is came out that in fact it is pending. So such type of statement has serious consequence. And you are when you are making such a statement to the government advocate and on the basis of which also you are making the statement, the consequence would be very dangerous because he definitely will dispose of the matter and he will now go and file an application to get that order, certified copy of that order, and it will be found that there is no such order because the case is still pending. These are the things to be careful in future. So
He may have done it hastily without verifying, but should not be done. No, and another thing is, if we accept documents here, you are also filing it hastily. So if you file it there, you will do it properly, with abundant caution, and then it will come on record. Here we are taking it on record, and thereafter you find that.
ଆପଣଙ୍କର ଅଫିସର ଆସିଲେ ଠିକ କୋର୍ଟରେ ପହଞ୍ଚିଗଲେ ଆପଣ ଗୋଟେ ଡକୁମେଣ୍ଟ ବଢେଇ ଦେଲେ ଆପଣ ବି ସେଟା ଫାଇଲ କରିଦେଲେ ମାନେ କେତେ ଦୂର ସମୟ ତାକୁ ପାଇଥିବେ ତା ସାଙ୍ଗରେ interaction
verify.
କରିବାକୁ on that document that is also ତେଣୁ ବହୁତ ସମୟରେ ଏଇ ପ୍ରୋବ୍ଲେମ ଗୁଡାକ ଆସିବ
ଆପଣ ଯୋଉଟା ଦେଲେ we can't do anything because it has to come on record, replacing the synopsis and other thing, na?
yes Mr.
File करते हैं synopsis.
What is this item number 5?
Item number 5, my lord, it is challenging the rejection of petitioner's request to MCL for employment under rehabilitation scheme on the ground that the land trustee who was the grandfather of the present petitioner, he had nominated someone else, one Dibakar Sahu, who had been benefited with an employment from MCL.
You have why it was rejected?
Rejected because they said MCL said that already benefit of
Come to that order dated 17/9 which you are challenging,
Yes,
annexure 17.
It upon
Yes,
the
madam. Page
document,
60.
Without
file
additional
document.
update.
We are not the filing register, how I could do it. This is the problem.
ଏଇଗୁଡାକ କୋର୍ଟରେ ଫାଇଲ ହଉଛି ଯୋଉଟାକ ସ୍କାନିଂ କରିକି ତାକୁ ୟୁଜ କରିବେ
Should be accepted in court. ସେ noting କରିକି ଆସିବ ସେଠୁ ନା court ରେ. So let's the whole idea is no paper here. Every day we are taking paper. Note of argument I can understand, but all documents they are filing here.
ଗୋଟେ ନୋଟିଂ ଦେଇଦେଲେ ହବ henceforth ଏଇ ଟାଇପ ର ମ୍ୟାଟର ହେଲେ ତାକୁ ବାଧ୍ୟ ହେଇ ତା ପରଦିନକୁ ରଖିକିନା ଆପଣ ମାନେ ଫାଇଲ କରିବେ ସେଟା ସ୍କାନିଂ ହେଇକିନା ଆସିବ
ଆଗରୁ file କରିଥିଲେ, we can call for it also.
Sorry for that.
Okay, because it was being accepted, so naturally we're doing it. It is
so
convenient for you.
you are challenging this annexure 17
Yes, madam. Yes.
so let us see the grounds
Page 62, last para, your lordship may kindly see.
page
62, my lord. Last para.
62 yes last paragraph
MCL has already provided 3 employment benefits in the family of Kathi Sahu, son of Sahib Sahu of village Daura against land acquisition. Dibakar Sahu has enjoyed the service benefit from MCL being nominated by Kathi Sahu in place of Basant Sahu from 1991 to 2018, that is for 27 years. MCL cannot provide further 4th employment benefit against land acquisition after providing all due benefits in the family of Kathi Sahu, son of Sahib Sahu. So they say, my lord, that this land house team, my grandfather Kathi Sahu had nominated one Dibakar Sahu for the employment, since my father was at that time employed under Nalco. Your lordship, for the time being, your lordship may kindly see page 37.
Who is Dibakar Sahu?
Dibakar Sahu is not the son of my grandfather, my lord. It is admitted that his son-in-law, my uncle, that is what affidavit I had given.
This is the subletting of that thing to get the job.
No, my lord, it is in fact
right there. How can
ମାନେ ଜ୍ୱାଇଁକୁ କହିଲେ ଜ୍ୱାଇଁକୁ ନେଇଯାଆନ୍ତି
Joy lectured son of
but se join no ho.
see
ନାଇଁ, ନାଇଁ, ଜ୍ୱାଇଁ
I would want to listen.
ନାଇଁ, ଜ୍ୱାଇଁ ବୋଧେ
ଜ୍ୱାଇଁ,
ଜ୍ୱାଇଁ ଜ୍ୱାଇଁ
ଜ୍ୱାଇଁ।
ଜ୍ୱାଇଁ ଯେ ସେ
ଜ୍ୱାଇଁ।
ପୁଅ ଯେହେତୁ ଅନ୍ୟ ଇଏ ଥିଲା ନାଲକୋରେ ହଁ whether Dibakar Sahu is the son-in-law or
yes, sir, son-in-law of original land house.
son-in-law को भी चाकरी दे हवा.
ଚାକିରି ଦେଇ ହବନି, ସେ ଲେଖିଛନ୍ତି ବା ଫାଦର ନା ଲେଖି ଦେଇଛନ୍ତି କାଠି ଥାଉ
ବାପା ନା ଲେଖିଦେଇଛନ୍ତି
ଇଆଡେ ଲିଗଲ ଏରେ ନାହିଁ. ଅଫିସ କମିଟି
नहीं,
ରିପୋର୍ଟ
because I have seen earlier cases से adopt भी करके चाकरी दे दियंती.
ଆଡପ୍ଟ କରିଥିଲେ ତ ତାର କିଛି କାହିଁକି ନା ଏଠି ନିଜେ ଲେଖୁଛନ୍ତି ତାଙ୍କ କମିଟି ରିପୋର୍ଟରେ କି ସେମିତି କିଛି ନାହିଁ ହାଉ ହି ୱାଜ ଏମ୍ପ୍ଲଏଡ.
all right let us say on the recommendation of that Kathi Sahu
Again,
Dibakar Sahu got the job got
That-
the service in MCL
My
then what
lord,
happened
that is what it has been. That is the ground in the impugned order, my lord. The
Okay.
lordship may, for a moment, kindly see page 37.
Here are not अच्छी क्या बाहर चलती.
Again,
Okay, continue. What? Please continue.
ये petitioner की Kathi Sahu ର କଣ
Nati.
କି କଣ କହୁଛି?
କିଛି ନାହିଁ, ଚାକିରି ପାଇଁ ଲାଗିଛି.
ମାନେ ଯିଏ ଚାକିରି ପାଇଲା ତାମାନେ ଯଦି ପ୍ରକୃତରେ ସେ ଜ୍ୱାଇଁ ହେଇଥାଏ
ତାହେଲେ
Kathi
ଆ
Sahu ର ୟାର ପିଇସା ହବ
ଆଜ୍ଞା.
ସେ କହୁଛି ଯେ ପିଇସା ଆମର ନେଇଯାଅ ଚାକିରି ନା ତାକୁ ଦିଅ ମତେ ବି ଦିଅ.
ନାଇଁ ନାଇଁ, ପିସା 2018 ଟର୍ମିନେଟ ହେଇଗଲେଣି, ରିଜାଇନ କରିଦେଲେଣି ଜବ୍ ରୁ. କିନ୍ତୁ ପିସା ଚାକିରି ପାଇଛନ୍ତି ବୋଲି ଏମାନେ ଯେମିତି ତନାନା କରିଛନ୍ତି ତାପରେ ଜାଣିଛନ୍ତି ଜେଜେଙ୍କ ନାଁ ଲେଖିକିନି. That is the whole.
so
Yes, how it.
no let us say that the on the recommendation of the original land houstee
My lord,
that the ex got the job
my lord.
then it is to be given once na
Yes, my lord. Once,
so
but the issue now is
yeah
the MCL committee's report itself says that there is no evidence as to how he was sponsored, that Dibakar Sahu was sponsored, either by the land house or how. They do not have any record regarding that, my lord. That is at page 38. A committee was formed.
38
Yes, my lord.
yeah
Observation of committee.
Hmm.
There is no record to show that the recorded tenant Kathi Sahu or his son Basant Sahu had nominated Dibakar Sahu for employment in place of Basant Sahu. The legal aid certificate of late Kathi Sahu issued by Tahsildar Talcher Annexure C does not contain the name of Dibakar Sahu as his son. However, it contains the name of Basant Sahu as son of land trustee Kathi Sahu. From the service record of Dibakar Sahu, Annexure F, it is seen that he has declared his wife as Jana Sahu. The legal certificate of Kathi Sahu.
There will be disturbance in the family.
Disturbance ହେଇଗଲାଣି ଆଉ।
ये दिवाकर साहू रो छुआ नुह ये
दिवाकर साहू काठी साहू का पिला नहती।
नहीं नहीं
ये
that is
होची
all right.
ये होची बसंत साहू।
नहीं नहीं I am on the point कि दिवाकर साहू किए
दिवाकर साहू इट पे लिखिले से जोई काठी साहू कर
सेटा मते डाउट अछि अवश्य जमा नथिबो
इट पे लिखा है ताकरी कोई ये होची जना साहू
anyway ये होची पुअर पुअ
ये होची पुअर पुअ हां ये पिटिशनर होची पुअर पुअ।
No, how it is missing, I am to say that service record टा जेतेबेले मेंटेन होउतिबो एटा जदी ए केस गुडाक on the nomination of somebody
Malor
he is to get the job
Malor
then ताले से nomination paper टा केमती पळेला पडे
ते लिखित ताकरी कम
हां
ये के सवन है ये वीडियो से
by issuing notice so there is likelihood of further disturbance in the family.
ହେଇଗଲାଣି ଆଉ ସେ ତ ମାନେ allegedly ମୁଁ ସେଟା ଲେଖିଛି affidavit ରେ ତାଙ୍କରି କଥାରେ ଯେ already also Dibakar Sahu is dead but they could not provide they did not.
But another thing, the land trustee has to nominate. He has not. If he has not nominated you also, how will you get? मत बोला नहीं अब nominate का कौन नहीं? ये को बात है कितना वर्ष पर है?
Nominate तार सेटा कौन अपन का procedure कोई?
Again nomination टा
यदि suppose let us say
again
hold that there was no nomination for that by that original land trustee पे जो कंपना काठी साउ हला काठी साउ रो मने करंतु तार नाही काकू नॉमिनेशन करनी
आगे
ताहले तारो नाती पाई परिवो बोली
आगे
को ग्राउंड रे अपन कोइ
काठी साउ हैड नॉमिनेटेड बसंत साउ
काई कोड
80 page 24 and 24 serial number 3 Kathi Sahu son of Saheb Basant Sahu
कितने पेज कितने
24 man
24
annexure 2
हां
column number 3 it Basant Sahu को से ये पर
बसंत साहू टा किए
Basant Sahu the petitioner father
के पार बाप
सीरियल कितने 3
again
ये तो दी जण को नॉमिनेट कर
नहीं
ता ऊपर टा देखो
Tripura Sahu again
कौन सर ये कौन माने what is the सेतबेले स्कीम कौन थिला
scheme my lord regarding this whether one or more I will go through that my lord kind of सेतबेले scheme टा जहा थिला से कागज मिलुनी से कागज मिलुनी एबे तो गोटे now it is one
नहीं इवन धर नॉमिनेट कला दीटा
आगे
जण को तो हबो बट माड गळ लागि पुनी से
नहीं नहीं whether जणे दी जण को नॉमिनेट करि परिवो की
I will try to find out kind of पुराना स्कीम टा पाइली ते कहि चंती आनी किन देबे
जण को नॉमिनेट करले कि आउ जण चाकरी पाइला
आउ जण चाकरी
हां
एमसीएल रो स्टाफ केतटा जिबे बोले बिकरी एतमे आ कागज मिलुनी काठी साउडा मरला केबे
काठी साउ
अच्छी डेट चार्ट रे कोन डेट चार्ट भी दबार थिला बधे ना खाली से नॉप्सिस ଦେଇଛନ୍ତି
ଏଇଟା ଗୋଟେ ଜଷ୍ଟିଫିକେସନ ଆସୁଛି ଯେ କାଠି ସାହୁ ବସନ୍ତ ତା ପୁଅକୁ ନମିନେସନ କଲା ନୋମିନି କଲା ବଟ୍ ଯେହେତୁ ବସନ୍ତ ସାହୁ ଆଉ ଗୋଟେ ଜାଗାରେ ଜବ୍ ପାଇଯାଇଛି he didn't opt for it କିନ୍ତୁ what about this Tripura ସାହୁ ଯୋଉଟା has been pointed out
I'll take instruction
ସିଏ ବି ଲେଖିଛି ନା ସିଏ ବି ଗୋଟେ ପୁଅ
ଆଜ୍ଞା
ଦି ଜଣ ପୁଅ ଲେଖିଛନ୍ତି ନା ତେଣୁ ବସନ୍ତ ସାହୁ କଥା ଛାଡି ଦିଅନ୍ତୁ
ଆଜ୍ଞା
ତ୍ରିପୁରା ସାହୁ କଥା
ଯଦି ତ୍ରିପୁରା ସାହୁ ଇଏ ହଉଛି କାଠି ସାହୁ ଦି ଜଣ
ନା ନା ଏଇ ଯୋଉ ନାତି ଏବେ ଆସି ଆଶିଷ
ବସନ୍ତ ସାହୁ
ବସନ୍ତ ଆଉ ଗୋଟେ ଜାଗାରେ ଚାକିରି କରୁଥିଲା।
ନାଲକୋରେ ଚାକିରି
ନାଲକୋରେ ଚାକିରି କରେ, ନାଲକୋରେ ଚାକିରି। ସେଇଥିପାଇଁ
That Tripura Sahu was provided with employment from NCL itself.
ତାହେଲେ
Tripura Sahu was employed with NCL itself.
ତାହେଲେ 2% ମିଳିପାରିବ କି କୁହନ୍ତୁ? That is the main
yes
question.
sir I'll
ଆପଣଙ୍କର ସ୍କିମ୍ ସେତେବେଳେ ନିଶ୍ଚୟ ଥିବ ଏଗୁଡାକ।
ଦିଟା ଏବେ
ହଁ।
ସେ ସ୍କିମ୍ ଟା ଆଣିକି ଦେବେ କହିଛନ୍ତି ନୂଆଟାରେ ଗୋଟେ
ଆଚ୍ଛା ଆମେ କରିଦଉଛୁ relevant scheme to be produced.
Yes,
I
sir.
think son-in-law there is no problem. ବହୁତ ଲୋକ son-in-law କରିଛନ୍ତି. Though actual son-in-law ki we don't know, but lot of people have nominated son-in-law.
There must be something in that
Is that-
scheme
ନା,
that suppose some ସେତେବେଳେ
son ନଥିବ।
ଆଉ ଗୋଟେ ଇଏ
ହେଇପାରେ
ହେଇଗଲା।
ହେଇପାରେ
ହଁ,
କିନ୍ତୁ my case is ମୁଁ କେବେ ଆମର କେବେ ବି nominated
ନାଇଁ
ହେଇନି।
that's your case ମାନେ ଆମେ ସ୍କିମ୍ ଟା କଣ ନ ଦେଖିଲେ
ଆଜ୍ଞା।
କିଛି
That is-
କରିହବନି। ଲେଖନ୍ତୁ Mr. Das has filed the additional affidavit of the petitioner, which is taken on record. Copy of the additional affidavit we served on the Land Council for the state. Achi copy achi,
ଆଜ୍ଞା
which is served on the in court. During course of argument, the Land Council for the petitioner took some time to produce the scheme which was prevalent at the time when Annexure 2 was prepared. That Annexure 2U says that as per the RR policy, that was
yes ma'am
Annexure 2 dated 22/9/2010 was prepared. କେବେ ରଖିବା କୁହନ୍ତୁ ଆପଣ ସ୍କିମ୍ ଟା
either any day next week maybe
ଆଚ୍ଛା please this matter next week. This is taken on record for this, no? So you can apply also in the RTI specific marking.
they have done that.
Donanti.
They have done that. That
Whether
is
there
my-
is any scheme, provide
Yes,
us with
that is
it.
the instruction and
So-
they have done.
Yes. Just we are coming with it.
The opposite party my lord. I am for the opposite party my lord, character.
My lord, in this item 6, my lord, I seek 2 weeks time, my lord, to file another affidavit. I took time previous occasion. But same is ready, you file within 10 days. After vetting, they were sent for vetting. The concern after 27th any date, because the concerned official is leave. You will join on 27th, so after 27th any date that's convenient.
In the first order, Mr. Pari, in
My lord.
4/12/2024, an order was passed that Learned Counsel for the petitioner seeks some time to verify whether there is any specific rule framed by the petitioners, means that if someone discharges his duty in the higher post, he will not be entitled to get the officiating pay. That was the crux of the matter in this case.
But that is the annexer R/2.
Because his prayer was that to grant him the officiating pay and allowance for discharging his duty as SPM in Dukura SO.
Yes, sir.
That
Very
has
well.
been torn down, and that he is challenged, and it was allowed by the in the tribunal. So
Well, in this respect, we refer to the annexer R/2, page 70 of the OA. And basing on that, we want to file an affidavit. My lord,
all right, you have already taken 3 adjournment. From the Learned Counsel for the Mr. P.K. Pari, Learned Deputy Solicitor General, along with Mr. D. Gochar, Learned Central Government Council, 2 weeks more time to file the additional affidavit. As per the order dated 4/12/2024. Of this matter, in the commencing from 17th ନେଇ ଆସିବା 17th of February 2025. Yes.
Item 7.
Item 7 will not since 19th November. I have applied for certified copy of the lease deed. Till date, I have not received. So more time may be allowed to.
All right, Mr. Bonamari Sahoo and Council appearing for the petitioner submitted that is yet to receive the certified copy of the original lease deed, which has been applied for, and the matter may be adjourned for 2 weeks. Like it's some other 4 weeks.
So 4 weeks. 4 weeks.
4 weeks. 4 weeks. Is this matter and we commencing from 3rd March 2025? Yeah.
Item 8.
You were granted twice time. But the further some more time may be given. It has to be a word matter. Se utkosh orja ଚାଲିଥିଲା ଇଡକୋର ସବୁ ସେଥିରେ engage.
Counter not filed will be filed.
Instruction
Who is appearing for the
And for the petition.
petitioner? All right.
17 ରୁ ରଖିଦିଅନ୍ତୁ
17 ତାରିଖ. All right. Mr. Pradeep Mohanty, Land Senior Advocate, 6 weeks time for filing the counter affidavit. Land Counsel for the petitioner is present. Is this matter in the commencing from 17th February 2025. Copy of the counter affidavit filed in the meantime, serving a copy on the Land Counsel for the petition. Yes.
Item 9.
Item number 9, Kashif was directed to for a specific instruction, but if the land is available for the allotment or Price there.
We have mentioned in the order that Land Council for the State submits 21/1/2025.
Yes, sir.
That though the instruction has been received from the concerned authority,
That is not in consonance
but the
with the order.
point which was raised by the Land Council for the petitioner also reflected in the order dated, but specific instruction has not been answered in the written instruction.
Thereafter, one more communication has been made. She may grant me 1 week time so that the instruction can be followed.
This is item number 9. List report support ହେଇଛି ତାପରେ ସେ draft list ଗୋଟେ number ଅଛି ଗୋଟେ correction ହେଇଯାଇଛି ମାନେ the Land Council for the petitioner takes 1 week more time. Okay.
State. Council for the state.
The Land Council for the state is 1 week more time to an instruction as per the previous orders of this matter to be commencing from 17 February 2025. Mr. S.K.Sahoo Hon'Ble, Land Senior Advocate, is present for the petitioner. Yes.
Item 10.
And the IO and the public application by inserting amendments regarding the 300 for filing the writ application.
1902 of 2025 is an application for amendment. So you want to insert some paragraphs.
Regarding the
After paragraph 11, one paragraph you want to add. And you are also to change the and no prayer you don't want to change. So only that paragraph. So giving copy to the Land Council. So have you any objection?
I'll file.
Yes.
I'll take instruction whether to file objection or.
He's only narrating facts. For that, he'll get a chance to file a counter affidavit in the writ petition.
I've got the copy yesterday.
All right. Tomorrow you want. IN number 1902 of 2025 is an application for amendment. Land Council for the state submits that she has received the copy of the interim application and the matter may be taken on tomorrow. Out of this matter. So, in the punch, we have purchased. Along with for the there will be a good amendment.
The connected application also has an IA.
1903 of 25. Order for 1903.
For this, madam, for this you may not have to get instructions.
I just go through.
So, this is part of his writ application. Thereafter, if you notice, you'll get a chance to.
I got the copy in the morning itself. I just go through.
Next.
Item 11.
Lords, in item 11, I here in writ petition 30798, the writ petition filed by Indian Oil. I have served the copy. And this is connected with the writ petition 21, which is also listed, in which my lords has stayed the Indian Oil letter of 22nd August. Because my lords, what has happened here is that we paid compensation to opposite party number 2. And opposite party number 1 says he's the real owner, so compensation should have been paid to him. So we're in a quandary now because it's public money.
No, who is appearing for P number? Mr. Mahapatra, you are appearing for that.
Yes.
Then who is appearing for that Umakanta?
Before notice, I have appeared for Umakanta. Miss Pratyusha Naidu is appearing.
She is not a party
No,
in that.
Yes, she's a party.
The party, but she's appearing in the other connected.
No, we just want to know that in the first writ petition, that is WPC number 30 so and so, whether that she is a party or not.
Yes, she's a party. She's a party. She's opposite party number 2.
Have you served a copy on India?
Yes, I have served a copy on all the opposite parties.
No, because the order which was passed, order number 1,
Yes,
the
ma'am.
only order that was passed, that
Yes.
the copy is to be served to the learning council for the opposite party number 1.
Yes, my lords,
There
I've
is-
served my learned friend.
But you have served the copy on Miss Naidu also.
Yes, Miss Naidu as well as.
Where is Miss Naidu?
He is the petitioner in the connected with petition.
No, it's all right. She is not present. We just want to get confirmed that she has received the copy of the first read petition. That's all we just. We are keeping it tomorrow. Please, if you just intimate Miss Naidu that WPC number 21599 of 2020 non-appears for the petitioner. Land counsel for the opposite party is present. Put up this matter tomorrow along with WPC number 30798 of 2024. Mr. Mahapatra submits that he will intimate Ms. Naidu about the order passed today. Opposite parties total.
In this matter, my lord, so far as the IOCL is concerned, they had referred the matter to the learned district of Puri to find out who is to get the money. And accordingly, he has passed the hour. Now, how I feel, how IOCL is agreed. The contesting party, Mrs. Naidu has already filed a writ petition saying that I am entitled to get.
No, if the decision has already been taken by the district judge.
Yes, in my favor.
In your favor.
Yes. Now whether I will get on.
So if that becomes the final or
yes, ma'am. So how IOCL is agreed?
Because IOCL has already paid. So unless some order is passed regarding that, they
that
must be agreed.
That order has already been passed by learned district. Now Umakant, the other beneficiary, he has challenged that to Mrs. Naidu, and that will be adjudicated. But I fail to understand how they are agreed.
I'll just address that. My lord.
So can that be adjudicated in a read petition against that order?
That on merit I will place before your lord.
My lord, I'll satisfy my lord. Our singular ground is that when this matter came up before the learned district judge, the land in question is already subject to a mutation appeal. So that's when the land title is not clear. And it is also taken into account by the learned district judge that there is a mutation appeal which is sub judice before the sub-collector. How then did the district judge go and allocate
land title has already been decided by the Honorable Supreme Court.
At the end of the day, 47 lakhs have been paid. This is public money.
Protect the position.
I just want to protect myself, but either way, I'm not being.
No, that's right.
Because then my officers then.
No, it's all right. District judge order. Have you got the copy?
Yes. That is they have annexed at page 24. In their version.
Page 24.
24 in their petition.
Okay.
Maybe pardon your lordships.
You are there now. We had mentioned that you didn't appear when the matter was called. So now delete that. So we want to ask you, Ms. Naidu,
Lordships.
that in the first read petition, that is on WPC number 30798 of 2024.
Lordships.
The opposite party.
Lordships.
You means the
Lordship.
Umakant
Panda and others. Lordships.
and you.
Yes, lordships. I'll appear, but copy has not been served.
Not been served.
No, lordships. I came to know in the morning itself.
Service can be.
The submission was made by the Learned Council for the Indian Oil Corporation, Mr. Matthews, that he has already served a copy on you.
Soft copy, probably, my lord, my learned friend must have served, I think 15-20 minutes back on my legs here, your lordships. So I probably have not opened it. So that is I apologize if that is so. Okay. But a hard copy, I requested him to serve.
All right. So why don't you file your appearance in that?
Lordships, I'll do that, your lordships.
Okay, so that can it be taken up tomorrow if you have no difficulty?
Your lordships, next week if possible, your lordships.
Right, next week. Let me.
Pleasure.
You set up you say that you order pass it. You take down in WPC number 30798 of 2024. Mr. Sunil J. Matthews, Land Counsel, for the petitioner is present. Mr. Ashok Kumar Mahapatra, Land Counsel, appearing for the opposite party number 1 is present. Ms. Pratyusha Naidu, Land Counsel, submits that she has instruction to appear for opposite party number 2, Umakanto Panda, and she has received the copy of the writ petition today morning, and the matter may be taken off next week. As prayed for, list this matter in the week commencing from 10th of February 2025, indicating the name of Pratyusha Naidu as the counsel for the opposite party in the cause list, along with WPC number 21599 of 2024. It will come next week, Miss Naidu.
My lords, I'll be there. I'll take the copy in another before lunch. My learned friend may kindly wait for.
Okay.
Oh, pleasure.
Item 12.
12 minutes of prep for 10 days time to comply with the order dated 23/12/24.
23/12/2024. On order agent, Mr. Das and additional government advocate shall take instruction under which provision of the Tahsildar Kishore Nagar of OEA case number 1 and pass the informed order. So who is to dispose of the OEA application?
Tahsildar has disposed it of.
No. Who is the competent authority? Perhaps that was the reason why such an order was passed on 23/12/2024.
There have to be some notification specifying the officers who have to appear in different subdivisions. Please.
तहसीलदार किशोर नगर
Area
विभिन्न एरिया ପାଇଁ ଯଦି allot ହେଇଛି ତାହେଲେ ଏଇଟା ପାଇଁ ଯଦି allot ହେଇଥିବ it's all right ସେଥିପାଇଁ ଆପଣଙ୍କୁ ଆଇଥିଲା. So if you are to produce that notification, what is your instruction?
As per instruction, the Tahsildar is the competent authority, but
ବିଭିନ୍ନ ଯାହା point out କରାଗଲା ପରା ଗୋଟେ particular ତହସିଲଦାର କୁ କେତେ ଗୁଡାକ ଏରିଆ ପାଇଁ ଦିଆ ହେଇଥାଏ ସେ application କୁ deal କରିବା ପାଇଁ. ତେଣୁ ଏଇ ଯୋଉ କିଶୋର ନଗର ତହସିଲଦାର କୁ ଦିଆ ହେଇଥିଲା କି ଏଇ ଯୋଉ ଇଏ କେସ୍ ଏଇ ଏରିଆର ଡିସ୍ପୋଜ କରିବା ପାଇଁ ସେଇଗୁଡାକ ଦରକାର. So you have not taken up to that ground. But whatever it may be, just verify it. Land Council for the state took some time to obtain instruction as per the order dated 23/12/2020. Put of keber kyo satra is this matter on 17th February 2025. 18. Oh, 18/12.
Here, Mr. Misra.
yes,
And Mr. Kalpataru Misra, Land Council for the petition, applied delivery, State Council 615.
Item 13.
may I please now? Last occasion, Manders asked me to obtain instruction with regard to the expression used under Annexure 6 in the input letter, the word honeycomb structures in that. And I found it from the chatgpt.com, that is the AI tool. But the expression is the honeycomb structures likely refers to clusters or small scattered settlements, encroachment, or unauthorized structures that are present on land acquired by MCL. These structures could be either residential or commercial and might have been established by individuals or groups prior to or after acquisition of land by MCL. This is the expression meaning of that structure. My case is the land was active.
You are challenging Annexure 5 and Annexure 6.
6, and so also the second prayer for survey of the land, the structures, and for compensation towards the structures.
Okay.
The second prayer.
So why annexure, what are annexure 5 and 6?
Annexure 5, my lord, the page 22, the, my lords, in reference, submission of a detailed report on the issue of demolition of structures constructed post 91 notification under CBA AD Act 1957 required for extension of mining activities of Jagannath area required in the immediate future. In reference to the above caption subject, we would like to apprise your esteemed office of the following details regarding the demolition of structures constructed after issue of 91 notification under CBA AD Act 1957. The priority of list of 91 structures to be examined and demolished for unhindered mine process is tabulated below. We belong to serial 1 Hiloi. The approximate number of 91 structures 97. And this is the timeline fixed by the MCL authorities.
Then
And thereafter, the collector issued the letter under Annexure 26. This
annexure
is
6
Annexure 6, page 23, my lord.
dated 5/12/2024.
My lord.
Yes.
My lord, Collector Hon'Ble issued this letter to the sub-collector.
Yes.
And placing the letter with reference to the above cited subject, I am to say that the shifting, demolition of honeycomb structures are being taken up as per the demands of the MCL operation. The matter is being reviewed in high level meeting regularly, and as a latest progress, the MCL have been advised to make strategic plan for demolition of small patches of honeycomb structures on priority basis. Accordingly, the general manager MCL Jagannath area, Konya area, Bharatpur area have submitted priority list of such structures to be examined and demolished in phased manner. Copy of the requisition letters submitted by general managers are attached for ready reference. You are therefore requested to verify the structures by 15th December 24 and schedule demolition of non-residential or commercial units by 20th January 20 to make the required land encroachment free for unhindered mining process in coalfields of MCL.
Yes. So what is your grievance?
My grievance is we have built the construction. We purchased the land prior to 4/1 notification. Conversion was made before 7/1, and structures are made also before 7/1. They are saying you have made the construction after 9/1. My lords also delivered one judgment, that is reported judgment. My lords is the author of that judgment.
No. Please tell us,
My lord.
Why these two letters have to be passed?
My lord.
You want us to pass these two letters. One is
My-
dated.
Our object is let the MCL authorities make a survey, assess it, and determine the compensation. Our matter will be ended.
The letter is also like that you are requested to verify the structure by 15th so schedule demolition of this one. So
They
it
are
is
not
not that
assessing what is not there. They are not making the assessment of the structures. That is our grievance. They are saying it is after 9/1. We have satellite pictures, and on the satellite pictures, my lords have delivered a judgment. That is doubtful, and my lords allowed the repetition. That is the reported judgment, my lord.
Access, my lord, will see. I think this is a handwritten note on the same. Annexure 5, my lords, look at. There's a handwritten note. The collector, sub-collector Talcher, please assess and fix demolition dates.
assess no likhais. Assess no କେମିତି demolition କରିଦେବେ ତ?
Assess କରିନାହାନ୍ତି ସାର୍, ଏବେ ବି ଆମ structure ଅଛି.
ହଁ,
Let he file the affidavit. Because the the district administration has issued the letter by Annexure 6.
ଆଚ୍ଛା ଏପର୍ଯ୍ୟନ୍ତ access ହେଇନି ବୋଲି କହୁଛନ୍ତି।
ଆଜ୍ଞା।
ଆପଣ instruction ଇଏ କରନ୍ତୁ ଲେଖନ୍ତୁ। Instructions ନିଅନ୍ତୁ। This expedition has been filed by petitioner S.K.Sahoo with a prayer to pass the letters so and so. and with a further direction to work out the measurement work and assessment of the structure over so and so. He has referred to Annexure 5, which is the letter of the General Manager Jagannath area of MCL addressed to Collector District Magistrate on good dated 18/11/2024, wherein it is mentioned the name of the village of the petitioner finds place, that is Aloi and Iloi, Iloi. And in the very letter, the sub-collector, the collector has mentioned to the sub-collector oblique sub-collector to assess and fix the demolition date. The Land Council for the petitioner submits that structure is still in existence.
Annexure 4 to that effect. May I read my letter?
Structure is still in existence, and till date, no assessment has been made.
Assessment and measurement.
No assessment and measurement has been made in accordance with law. And if without such assessment and measurement demolition takes place, then the petitioner will be deprived getting the amount
Benefit of
RR policy. Let the Land Council for the state obtain instruction whether in pursuance of the instruction imparted by the collector district magistrate on good to the sub-collector Talche, any assessment and measurement has taken place or not, and if so, the report shall be produced on the next date of this matter in the week commencing from 17 तारीख instruction.
Till then, will the status quo with respect to the structures.
Sir,
status quo ନଦେଲେ ସେମାନେ ଭାଙ୍ଗିଦେବେ। ସିଆଡେ ତ ତାରିଖ ଆସିବେ ଘର ମାନଙ୍କୁ ଫଳି ପଡିବ।
ଏ ଲେଟର ଇସ୍ୟୁ ହେଲାଣି 12/11/2024।
ସାର୍ ମୁଁ ରାଇଟ ଟାଇମ ରେ ଫାଇଲ କରିଛି।
ହଁ,
କିନ୍ତୁ
12/11/2024 ରୁ ହେଲାଣି ଆଜି ହେଲାଣି ଫେବୃଆରୀ ମାସ, ସେମାନେ ଏପର୍ଯ୍ୟନ୍ତ ଆପଣ କହୁଛନ୍ତି କିଛି ହାତ ମାରିନାହାନ୍ତି।
25 ଜାନୁଆରୀ ଯାଏ ଥିଲା ନା, ସେଥିପାଇଁ ହାତ ମାରିନାହାନ୍ତି।
No, no.
Status quo ରହିଲେ ସାର୍
Pass the necessary instruction to if it has. Yes. Next.
Item 14.
Assembly order 28/2/2024 in WPC number 38864/2023.
कौन order निकला?
Order my lord, requisition disposal with the direction to opposite party to consider the representation of the petition.
Representation ଆପଣଙ୍କର ଏପର୍ଯ୍ୟନ୍ତ consider ହେଇନି?
Ma'am,
କିଛି communicate କରୁନାହାନ୍ତି ଆପଣଙ୍କୁ?
no ma'am.
କିଏ opposite party number 3 କିଏ?
Opposite party number 3 LAO ଖରିଆର ma'am.
କାଲୁ ମାଝି।
କାଲୁ ମାଝି।
କଣ କରିବା? ଡକେଇବା ନା ବୁଝିବେ? ତାହେଲେ ଆସିବ ଆଉ। Land Council for the state seeks some time to obtain instruction as to whether the order dated 28/2/2024 passed in WPC number so and so has been complied with by the opposite party land acquisition officer or not, the contender or not, of this matter on 18th of February 2020. Yes.
Item 15.
Yes, ma'am. Item 15, my lord. Order dated 27/2004 in WPC number 3771/2023.
Opposite party to consider the petition filed by this one so within period of 3 months, 3 months of filing. किए consider करिवे?
LAO my lord.
हाँ, सही लोग। Same model.
It is section 28A of land petition law.
ये order देखी लिखी जो read order का देखी नहीं, ये 18/2 को रखी देंगे लोग को same।
18/2 man.
हाँ, 18/2 रे दीटा गाछ।
Mal.
Yes,
Oh.
next.
Item 16.
May it please, Malak. Malak, this is a petition, Malak, challenging the virus of a particular notification, Malak, which is the ORERA Amendment Regulations 2022. My lords, there's already a writ petition which is filed where order has been passed challenging this very notification. The ground of challenge of this notification is Malak, the hike of fees has been made by ORERA, whereas the power to hike the fees has already been taken away and given to the appropriate government by way of a removal of difficulties order. So, below that, if my lord,
It is to be tagged with that
Yes,
writ
Malak.
petition.
Yes,
So in that writ petition, counter affidavit, etc. has been filed, or it is not?
my lord,
Your
that
no
is still
instruction.
pending. Yes, I am not there in the.
It has come with a copy given on the
Yes, সেটা ଗୋଟେ ଯୋଉ association ଅଛି my lord of the developers, that is CREDAI, the association had filed.
Right.
Yes, ma'am.
So what? She ଦେଖିଲ ଗୋଟେ
ସେଇ ଜଣା ପଡିବ।
WPC 9972 of 2023.
WPC ରେ। WPC 9972 2023।
She did. आपण माझं नाही computer.
View.
Computer.
Latest order to upload.
Latest order was 2024.
Time.
नाही देखुଛୁ ତାର date fix ହେଇଛି ସେ ଏକା date କୁ ରହିବ, that is the reason.
मैं काउंटर एफिडेविट फाइल ହେଇନି ତାଦେହରେ ବି ଦେଖଉଛି ଯେ in the mean time
ବର୍ଷେ ଆଗରୁ ସବୁ
ଏଇଟା ବି ବର୍ଷେ ଆଗରୁ ହେଇଥିଲା 24/2024। All right, this writ petition has been filed. My petitioner, Mrs. Bhagwati Projects, represented through its partner Swansea, challenging the notification number 3203 Big Rera dated 28/7/2022 under Annexure 1 being unreasonably arbitrary for initial and honest in the eye of law. The Land Council submits that the said notification is also the subject matter of challenge in WPC number 9972 of 2023, filed by High Orissa Private Limited and another. And in the said case, notice has been issued and counter affidavit is yet to be filed by the opposite parties, and this matter be tagged to the said writ petition. Copy of the order dated 2023 passed in WPC number 997/2023 is produced because which is taken on record. We verified from the High Court website that they said WPC number 9972 of 2023 was last listed on 24th of January 2024, and it was adjourned and the counter affidavit was directed to be filed. Stop. Put up this matter along with WPC number 9976 2020. Yes.
But there's an interim prayer in the
What interim prayer?
your lordship will see that order. The last para, it is clarified to Arab. Last page of that order is clarified that if petitioner number 2 hereafter applies under the RERA Act, read with the improved notifier registering any project, then the fees paid by the petitioner number 2 in terms of the said notification will be kept in a separate interest bearing account by ORERA and will be subject to final outcome of the presentation. जो fees hike है, I will deposit that in an interest bearing account and
Right, IN number 890 of 2025. This interim application has been filed for stay of operation of the notification pursuant so dated so party by so. The land council for the petitioner submitted that in the connected writ petition in IN number 4617 of 2023, it is observed it of court order. In view of such order passed in the connected with petition, it is ordered that if the petitioner, it's a number 2 jagger, petitioner, baki also yeah.
Okay.
Item 17.
So notice the order का passing main the petition से order कर दे. We should not counter affidavits once we filed the order one. Yes.
May I
Great.
take my notes? Notes in item 17, all are covered notes.
These
Let's kindly have a glance to section 28A of land acquisition.
one of the things.
Has to file within 3 months.
My lord,
So has that amendment been taken?
my lord, they have not. And the date also, the date of application, 28A application, there is no date mentioned.
Because Mr. Behra takes precaution that he mentions the date in the writ petition as well as in the because he has a number of cases. Last occasion we had asked him, he pointed out this amendment and mentioned it is filed within 3 months. You have to file an affidavit or an amendment application stating the date on which you have filed the application.
File an affidavit.
Section 28 within 3 months of disposal of that order.
So you, what do you do?
How can we ask them to consider if it is not maintainable?
In 2013, this application, when it was filed, it is not date not mentioned.
Explain.
Yes.
But the LA case number is 4 of 2003.
Original allocation. কিন্তু এই 28A application টা କେତେ ତାରିଖରେ ଦେଲେ ସେ ଡେଟ୍ ମଧ୍ୟ that is not mentioned.
ବର୍ଷ ବି ଲେଖା ହେଇନି.
ବର୍ଷ ଲେଖା ହେଇନି.
I have stated in para 5 of the writ petition.
para date mention ନାହିଁ.
Wait.
Let us see who's pointing out something.
That after coming to know about such enhancement of the compensation amount by the learned civil judge senior division Bhavani Patna in respect of similar kisam of land of same village like petitioner's acquired land, the petitioner applied certified copy of the judgment and after obtaining certified copy of the award, he filed a petition under section 28A of the Land Acquisition Act before the opposite party number 3 within the statutory period of limitation with a prayer to determine the compensation amount payable to them for the acquired land.
Within on which date?
You have to give the date. Just taking this amendment.
And it is also not mentioned in the application itself. Application is the annexure 2.
Land Acquisition Act 28. Just a minute. When an order allow the applicant something excess of one person interested in all the songs for a reason made up taken up within 3 months from the date of the court of visit. The request on compensation for the 3 months. Then the day on which the award was pronounced and contract has been excluded. अच्छा ये I think knowledge पर था सूची ये he was not aware about the कौन अपन ground है कौन petition of
He has taken the ground but not mentioned the date, so he has to mention. Then only we can write something.
all right in the this writ petition has been filed the writ petition has been filed by the petitioner Chanchola Nayak with following prayers for them. In paragraph number 5, it is stated as follows. When we put a pertinent question as to on what date such petition has been filed, the Learning Council for the petitioner seeks some time to obtain instruction. And by way of an affidavit you file, that would be better, no counsel. By way of an affidavit you will file the date on which the petition under section 28A of the Land Acquisition Act was filed before the opposite party number 3. Right? List this matter along with connected writ petitions. In all the writ petition also, similar order is similar affidavit is to be filed. It will be listed next week then? Next week or no?
The petitioner from distance place. Distance place.
Acha, ठीक है sir. Then let it come on 17th then. 17 2/2025. Yes. MOI file extension of a bail application. May discuss.
Supplementary list. Item number 1.
Applicant convicted. So RI for life mallet. Section 202 IPC. Admit for the trial court report. Interim application for bail and stay relation of fine to be considered of the receipt of the trial court report. Inclusion copy to be supplied to the bank council the state in the meantime. Yes.
Item 2.
The criminal appeal has been received by the 62 days delay into account of fact that to right, we are inclined to condone the delay. When the delay is condoned, part admit all for the trial court report. Madam
Item 3.
And he's convicted and is in custody around 11 years. And in the meantime, he has lived to his house for his household purpose 4 times.
No. You have filed 2 interim bail applications.
I am praying for interim bail because nice of the present petitioner.
No, which one? There are 2 interim applications.
That
One is for
IA number 320 of 2025.
So you don't want to praise the first one.
My lord, may I pray?
So your bail application was earlier rejected by one bench, which constitute. Okay. It appears that the earlier bail application of the appellant has been rejected by order dated 4/9/2023 in IA number 2075 of 2022. But note नहीं आसे better
खाली कितना earlier had earlier filed earlier
earlier rejected by rejected by
different benches.
Different benches. That the instruction be taken and the interim application be placed before the appropriate bench with the approval of the Honorable Acting Chief Justice. You IN number 389 of 2022. You do not want to praise this application.
My lord, I don't want to.
8 have not praised.
I want to praise only IA number 320 of 2000. I pray my lord, date of marriage is 7th, my lord.
It will be placed today, just and we will message not specific IN number 389. Dita division bench, Dita summer with it is 8 for them. Matter place for them, urgency achieve, list for it. Here.
Item 4.
This my lord, appellant challenge the order passed by the London additional session judge Jagat Singhpur, my lord. My lord, he London session judge, my lord, convicted the appellant under section 302
to my lord, conviction he
imprisonment
and life and pay fine and default in payment of rigorous interest.
So you have received the paper book.
Yes, my lord.
I have not received the paper.
To get the paper book, he wants to move the bail application.
This week
You get the paper book today and this year number 23 of 2020. The Learning Council for the state submits that he is yet to receive the paper book. And the matter may be taken up next week. We will let the registry supply the paper book to the Land Council for the state in court today. Court दे देगा receive करेंगे noting is और secret note करना है. Matter will be listed next week for consideration of the interim applications.
Item 5.
Only after this is the one interim bill is there, 2903 523. That one is not placed. IA number 2903 of 2023 is an application for interim bill. Land Council for the appellant does not want to place this application. Accordingly, disposed of as not placed. Another thing is that after the prisoner petition, some names of other councils are there. SP Das, SK Das, and Menda. That has not been. Since you are Mr. Deepak Ranjan Mishra. Since Mr. Deepak Ranjan Mishra and his associates have entered appearance on the basis of the prisoner's petition, the names of the other councils shall not be reflected in the cause de transport. IA number 1458 of 2023.
That he has appeared pursuant to prisoner's petition.
ଆପଣ business person order ନାହିଁ order ତ ଥିଲା ଆଥରକ ହେଇଯାଇଥିଲା no I thought ଆରେ ଆପଣ ଏତେ ଇଏରେ କହୁଛନ୍ତି ଆମେ କହିଲୁ we believe that your statement you are
Where is the prisoner's petition?
अच्छा and you have filed vnama अच्छा it have order ଟା କରିଦିଅନ୍ତୁ. Here is the prisoner's petition dated 17/9/2024. ଆପଣ କହିବା କଥା ଯେ prisoner's petition ମୋ ନାଁରେ ଆସିଛି ଏଇଟା କରିବା କଥା ଆପଣ କହିଲେ ମୁଁ already ଇଏ କରିଦେଲେଣି है ना ଦେଖନ୍ତୁ in which request has been made to engage Mr. Deepak Ranjan Mishra as his advocate. Mr. Mishra and his associates have filed vnama. It is accepted. तापर से और चल रही है deleted करेंगे. बाकी जो IA number 1458 of 23 is an application for bail and counsel for the petitioner appellant 6 for an adjournment till next week. Till next week. This matter next week.
Item 6.
And in case your filings
22 February 2017.
Okay. UTP, प्रोसीडेंट पीरियड UTP से तब देख के तो बाहर भी जाएंगे तो
ये तो दिया है
ना Facebook की भी some is right that he has almost remained in state of safety. For the Land Council for the petition, Land Council for the state. Land Council for the petitioner submits that the petitioner is in judicial custody since 21 to 2017. The occurrence in question took place on 19 to 2017, and PW1 is the husband of the deceased, Bhakta Handilkar, and he is the informant in the case, so also sole eyewitness to the occurrence. The Land Council further submits that it appears from the evidence of PW1 that the appellant came and asked the deceased give some handia, and when the deceased told the appellant that there was no handia, the appellant got angry and poured the boiling water which was there in a pot for cooking rice on the deceased, as a result of which she sustained burn injuries all over the body and was shifted to hospital and subsequently died. The Land Council further submits that in the cross-examination, PW1 has stated that the deceased had also consumed handia at the time of incident, and during tussle, the deceased fell down, and the apparent and the deceased fought while being intoxicated. It is the contention of the Land Council for the petitioner that there was no premeditation to assault the deceased, and on the spur of the moment, during grave and sudden provocation, the occurrence has taken place, and in the factual scenario, cannot be said that the ingredients of the offense under section 302 IPC are satisfied. Therefore, the bail application of the petitioner may be favorably considered. Land Council for the state opposed the prayer for bail and placed the evidence of the doctor bracketed PW12 conducted post-mortem examination over the dead body of the deceased and stated that the total surface of scarred injuries is about 50%, and the cause of death was due to complications of the scarred injuries. Considering the submission made by the Land Council for the respective party, nature of evidence reduced during trial, the surrounding circumstances under which the offense stated to have taken place, period of detention of the petitioner in judicial custody, and absence of any chance of early hearing, we are inclined to release petitioner on bail. Please. Serialization of time.
Item 8.
The speaker chief. One piece of it. Is it your first application or only rejected? You are in custody since when?
And that custody since 22/12/2016.
22/12/2016. Offense under 302.
Offense under 302.
Come to paragraph number 2 of the judgment, where the prosecution case is mentioned.
Read.
Please read it.
The prosecution case is brief is that the informant one Maninath Soni of Keramuta village appeared before IIC Rajampur PS on 21/12/2016 and lodged a written report to the effect that on the same night about 10:30 a.m. while his son Rohit Soni, the deceased, was near their village mound. At that time, one Abhay Kumar Baliar Singh, who was the health worker of Kupra, was going in his bicycle towards Sajbutoli. At that time, the accused Basu Indua, who was sitting by the side of the road, all on a sudden started pelting stones towards the Abhay Kumar Baliar Singh.
Basu is the appellant in this case.
Basu Indua is the appellant.
One appellant.
One appellant.
Yes.
He pelted stones towards the Abhay Kumar Baliar Singh. He is PW16 and snatched away his medicine bag, and seeing this, when his son Rohit Soni went towards them and tried to rescue Abhay from the clutches of the accused. At this, the accused got enraged and also pelted stones aiming at him. As a result of which, Rohit fell down on the ground, and while Rohit was lying on the ground, the accused brought a big stone and slashed his head by the same stone, causing severe bleeding injury on his head. And immediately thereafter, the local people who were present nearby caught hold of the accused, detained him, and informed the police. The informant further mentioned in his report that on receipt of such information, he, along with others, rushed to the spot and shifted Rohit to RGS Raulkela. But the doctor declared him as brought dead. He further mentioned that on the asked, the accused disclosed his name as Basu Indar of Sardu village, Jharkhand. By lodging this report, he requested IIC to take appropriate action against the accused.
So the eyewitnesses are there.
Eyewitnesses are there.
Who are the eyewitnesses?
Eyewitnesses are PW 1, 2, 4, 9, 11, 16, 20.
So many eyewitnesses.
Many eyewitnesses are there.
They have stated similar thing that you.
Yes, ma'am. PW 16 the person Abhay Kumar Baliar Singh.
You dealt stone hit the head of the deceased with stones. That is the evidence.
That is.
How many times?
Again. That is one stone. He has said that.
No, କେତେ ଥର ମାରିଛନ୍ତି?
ଗୋଟେ ବଡ stone ତା ମୁଣ୍ଡକୁ ଛେଚି ଦେଲା ବୋଲି
ସେତିକି ଖାଲି କହିଲି।
ନା ନା ଥରେ ମାରିଲେ stone ରେ ତାପରେ ସେ ଯେତେବେଳେ ପଡିଗଲା ଗୋଟେ ବଡ stone ନେଇକି ପୁଣି ଛେଚିଲେ ମୁଣ୍ଡକୁ।
ହଁ ପ୍ରଥମଟା ବୋଧେ ଛୋଟ stone ଟା ଥିଲେ ତାପରେ accused then brought a big stone and thrust on the head of Rohit. ହେଲା ଇଏ ହଉଛି evidence. Who is the doctor?
Doctor PW 19.
PW 19 doctor. Marcelo. Cause of death coma ରହିଛି ଆଉ।
Cause of death coma following multiple independent injuries is really heavy.
Presents many antemortem aberrant lacerations. Eyes closed. Each one, what all you will do. presence of many antemortem abrasions found all over the body. No, what is the injury he has noticed on the head? The external injury that is in eye?
Melody, external injuries there, melody, the first phase, melody, eye closed, conjunctive fail, pupils dilated, corona transparent, mouth partially
Page
open.
number?
Melody, same deposition 19 melody, page,
Uh,
melody, you'll see, can you see the paragraph 1, the melody,
Autopsy
headline
over the
is
dead body.
external appearance, melody.
External appearance. yes.
Melody. Then melody, internal injury,
No, external injury ପଚାରୁଛି ପରା ପ୍ରଶ୍ନ ଆପଣଙ୍କୁ ଯେ allegation ହଉଛି stone ରେ ମୁଣ୍ଡକୁ ପିଟି ଦେଲା
ଆଜ୍ଞା,
ଦୁଇଥର
melody, it is 3-4 times, melody, it has been written.
ହଁ ଯେ କାହିଁ injury କାହିଁ what is the corresponding external injury
That is not there on dissection, melody, on next page.
dissection ରେ କଣ ମିଳିଲା
Melody, next page.
next page ରେ କଣ ମିଳିଲା
On dissection, walls of abdomen were intact, territorium intact and pale, mouth partially open, teeth clenched, tongue intact.
fracture କାହିଁ
Actually, not that part is not.
fracture ନାହିଁ brain intact ଅଛି ନା
Membranes ruptured and pale, brain intact, presence of lacerations over the whole of the brain.
ପଥରଟା ଯଦି ମୁଣ୍ଡରେ ପିଟିଲା external injury ଆସିବ fracture କରେଇବ ତାପରେ hemorrhage ହବ କି brain ଯାହା affected ହବ ଏଗୁଡା ତ external injury ହିଁ କିଛି ନାହିଁ
Antemental laceration.
ଏଠି କୋମା ଦେଇଛି ଅବଶ୍ୟ
Pehla, all of the
No, it is
postmortem
only not
Antemental
ATM report ଟା
laceration.
ଟିକେ ଦେଲେ
TCR. TCR. Laceration, carnosal, parietal. Good.
ଏଗୁଡା ହଉଛି and see so many injuries are there he has this sometimes it happens these trial judges sometimes they do not write in detail that is the problem so it should be detailedly mentioned if there are injuries on the head
Yes.
and this has not been reflected in the deposition because some of them are on impression ଯେ ସେଇଟା ତ ମାର୍କ ହେଇଯାଉଛି ଆଉ ତେଣୁ ଏତେ ଡିଟେଲ କଣ କହିବା ଦରକାର that creates a problem but fact remains that there are injuries on the head
Yes, no, death is due to the head injury.
No, that is why we ask the reason and you see that even the next page of the antemortem fracture extending on the right temporal region fracture injury भी अच्छी and to the left
You said who is the doctor? PW?
PW 1919.
PW 21 টা কি না ভুল appeal আমি দেখছি
PW 21 who accused, who examined the accused.
who
PW 20.
21 what is your name?
Pasu Indian
Hindu
military
are.
representative.
আচ্ছা ঠিক এটা তো হচ্ছে ইয়ে তো
Rule 19 is the doctor who conducted postmortem exam. Postmortem report or details টা তা evidence point
ଖାଲି କହିଦେଲା
ଖାଲି this
a lot of aberration from the year but that
କାରଣ details ପୁରା ରହିଛି ଏଠି what are the fractures so you see right temporal region left occipital region
ଭର୍ତ୍ତି ହେଇଛି
ରହିଛି That is why doubted whether she lines and Bahari Pichinan, three Pichinan.
In coma following multiple and antemortem injury, excuse me, especially head injury.
तो आपनकर येटा पीरियड होची 2016
2016 22/12/2016 on the same day he was arrested on 21/12/2016 and forwarded 22.
What about the criminal antecedent? No antecedent. आनीथिले report. The land council for the state has produced the written instruction from the IAC Rajgangpur police station, which indicates that the address of the appellant in the post title is genuine and there is no criminal antecedent against the petitioner. The report is taken on the record. Book of this matter in the second week of March 2025. Yes.
Item 9.
ସେ ଗୋଟେ वकालत नामा ଦେଇଥିଲେ ଯୋଉ previous ଭର୍ତ୍ତି କରିକି ଦେଲେ ନା ସେଇଟା ଥିଲା 6 number.
Item number 6 Rosetta. Yes, item number 9.
My lord, as per my lordship's last order, I supplied deposition copies and bail application copy to the said counsel.
ଆଗରୁ rejected ନାହିଁ ତ?
No, my lord, first time.
All right.
You have received the deposition.
Yes.
So come to paragraph number 2. Let us see that what is the prosecution case.
The prosecution case in short runs as follows. On 3/1/17 at about 9 p.m., one Vishakha Bag, wife of Rashi Bag of village Chini Mahal, lodged a written report before the IAC Jamankira PS to the effect that Dovendra Pradhan, appellant of her village, had taken away her younger daughter Basanti at about 12 years back and had married to her. Her daughter has blessed with a son and a daughter. Since last 2 years, Dovendra Pradhan, suspecting on her character of her daughter, was assaulting her. On 3/1/17 at about 4:30 p.m., Dovendra Pradhan, coming from Jamankira, and assaulted her daughter and dragging her from village road, took inside his house and killed her by powering kerosene and setting fire. On her report, IIC Jamankira PS registered PS case number 217 dated 3/1/17 under section 302 IPC.
So it's a case of burn injury.
Only burn injury.
What are the materials on against you?
A material, my lord, case based on circumstantial evidence.
What are the circumstances?
Circumstances is marital life was not peaceful and extrajudicial confession and death.
Whose marital life was not peaceful?
Husband and wife. Present appellant is the husband.
No, you took that your wife to inside a particular room.
No, ma'am.
The appellant took the wife inside a room. That is in the paragraph number 2.
Dragging her from village
Dragging her
dragging her
his house.
from village road.
Dragging her from the village road inside his house. So a part ki diction.
That part no, your eyewitness is not there. Informant.
ଆପଣ ଏ ଡ୍ରାଗିଂ ଟା କେହି ଦେଖିନାହାନ୍ତି?
No,
ଆପଣ
my lord.
ଘୋଷାଡ଼ିକିନା ଆପଣ ସ୍ତ୍ରୀକୁ ଆପଣଙ୍କ ଘର ଭିତରକୁ ନେଇଗଲେ.
No, my lord, that no one said that. Only
ଆଚ୍ଛା, what about this dead body ଟା କୋଉଠି ମିଳିଲା?
From that room.
From that room only. So the cause of death is burn injury.
Cause of death is, my lord,
that is PM
PW18
finding.
says,
Cause of
PW18 says that he saw you leaving your house some minutes.
standard.
ଘର ଜଳୁଥିଲା, you left the house and went away.
So you drag your wife inside a room, and thereafter the dead body was found, and it was a case of burn injury, and the people also saw smoke coming out, and then you were, instead of saving your wife, you went away from the house, closing the door. That is the evidence of PW18.
Here, Mr. Rautray,
My lord.
have you gone through the depositions?
Yes, my lord.
When we are asking you a question that if anybody has seen him dragging, you are saying no, PW17 has seen.
PW17, my lord.
Yes.
PW17, Lankeshwari Pradhan.
At that time, the accused took away the deceased, dragging her inside the house. Pouchi to PW17 pouchi.
My lord, in
Fairly କହିବେ ତାପରେ
cross
then you can
examination.
take yes.
ଯେତେବେଳେ ଏମାନେ ଯାଇ ପହଞ୍ଚିଲେ, ଏଇ ଯୋଉ ପଡୋଶୀ ଲୋକ ସେତେବେଳେ ପୁରା ଜଳି ଯାଇଥିଲା ନା ବଞ୍ଚିଥିଲା? Is there any dying declaration?
No, my lord, dying declaration. My lord.
Oral dying declaration.
Dying declaration.
So what is your plea? How inside your room the dead body was found in a burning condition, and you, instead of saving your wife, you left the house just locking the door. In your 313 statement, what is your explanation? You dragged your wife from the road, took him inside, and then the house was that was on fire, and you left the house. Your wife, dead body was found, and kerosene was poured on her body. That is the doctor's evidence, and set fire. You have offered no explanation.
And a PW2 informant in cross-examination, it is stated that
Yes.
In cross-examination, it is a fact that the marriage of Basanti with the accused was a love marriage. It is a fact that both stayed peacefully for about 12 years after the marriage. It is a fact that I have not seen the accused assaulting Basanti, the informant, PW2. It is a fact that I have not seen the accused pouring kerosene on Basanti. When I saw smoke coming out from the house of the accused, I shouted and called others. Hearing my shout, Meenakshi, Sanjukta, and Ichidi and others came to the spot. And PW2 and PW17, sister-in-law, their statement is contradictory with each other.
ସେମାନେ ସମସ୍ତେ କହୁଛନ୍ତି ଯେ when they entered inside the house, they found the deceased was completely burned, and prior to that, se jo dragging katha alga katha, and villagers extinguished the fire, and it was found that the wife of this one who was inside the house, she was completely burned. And yes, one that PW18 has stated that the appellant told that he had committed a mistake and telling to pardon him. So these are all the evidence. କେବେଠୁ ରହିଲେଣି?
Custody since, my lord, 4/1/2017, more than 8 years.
for no explanation. Land counsel for the petitioner, land counsel. In view of the evidence available on report, the manner in which the crime has been committed, postmortem finding were not inclined to release the petitioner on bail. However, it is stated by the land counsel for the appellant that the appellant is in judicial custody for more than 8 years. Paper brief has already been prepared. Matter be added to the hearing list in the month of April 2025. Yes.
Item 10.
Sure, next week bail application next week. Yeah.
Item 11.
The appeal on behalf of Mr. Proraj, he will be permitted to play.
Yes, sir.
The first appeal. The appellant here, my lords.
Last date admission idea, na? 12/9/2024. So, have you supplied? You have been received the.
In this case, not supplied, but in connected case.
Gotti case, Supra.
There is out of one crime.
Deposition copy by game. There are 3 appellants.
Yes.
Altogether, how many persons were facing trial?
Each of them, 3 of them face.
3 of them. And offense under section?
Offenses on section 302 minutes.
302. So, please come to paragraph number 2, the prosecution case.
Informant is Montu Mahanta.
Yes.
He lost written report at Morda PS, alleging that on 10/6/2021 between 6 to 6:10 p.m. Kamal Lochan Mahanta, he is the appellant in criminal appeal 595. He came along with Jatindra Mahanta on a motorcycle, and Subhakar Mahanta came on a cycle with a thenga to his house site, claiming that the land belonged to them. And they quarreled and pushed Raghunath Mahanta.
What is the name of the deceased?
Deceased is Hare Krishna Mahanta. He is the grandson of Raghunath.
Hare Krishna Mahanta. Yes, please.
Raghunath, while the above 3 persons were abusing Raghunath, grandson of Raghunath, namely Hare Krishna, intervened in the matter, gave proposal to settle the dispute in a village. Accused person chased Hare Krishna, and on the road near a temple, Kamal Lochan gave a tangia blow on the neck of Hare Krishna, and all of them fled away.
Kamal Tangia neck.
Aye.
That is the sole.
That is the sole injury.
Kamal.
All have changed. 27. Petitioner number PW2, 3, and
The
7.
postmortem report has been discussed at page 26.
No, it's all right. We are now, let us, you, Jatindranath Mahanta,
Aye.
ଆଉ ଏଇ ଯୋଉ
ସୁଧାକର
ମହନ୍ତ ଏମାନଙ୍କ ନାଁରେ ସେମାନେ ଆସିଥିଲେ ସେ ମେନ୍ ଆକ୍ୟୁଜ ସହିତ ଅର୍ଥାତ୍ କମଳ ଲୋଚନ ସହିତ
All have also changed.
ହଁ ଚେସ୍ ଠିକ ଅଛି ତା ଛଡା ତ ଆଉ କିଛି ନାହିଁ. What is the PM report, Mr. Panda?
My lords, may look at page 26.
P214 is that.
PW. Who are the eyewitnesses to the occurrence?
2, 3, and 7.
PW2, PW3, and PW7. And doctor is
PW 14.
PW 14. That is the result of the death, the chop wound.
Yes, that
on
is
the neck.
chop wound. The cause of death is stated in para 27, hemorrhagic shock resulting from external injury.
Seven eight one of 2024 relevant IN number 1916 of 2020 is an application for bail.
Were you on bail during trial?
Yes,
The Learned Council for the
that is reflected in the judgment, page 9.
Mr. Panda, are you filing any memo or consent
Appearance.
memo of appearance?
Not filed anything. I'll file it.
Just to file it.
The council has to file actually on.
That reflect for the issue, but Mr. Devashish Panda, Land Council,
Mr. Prarat.
along with Johnson, submits that the petitioner is in judicial custody since February 11.
My lord, so far as petitioner Jodhu is 11/6/21.
Yoddu.
Aye, Jodhu and son
He was on bail.
Taken into custody.
taken into custody on
on
11/6 and then after that.
Taken into judicial custody on 11/6/2021, and he was on bail during trial. The Land Council further submits that judgment of our council that the prosecution case is that though this petitioner along with alias Kamal Lochan Mohanto bracket appellant in CRLA number 595 of 2024 and Sona alias Sobhakar Mohanto bracket appellant in CRLA number 717 of 2024 came to the spot holding weapons, but specific role has been attributed to the appellant Kamal Lochan Mohanto alias Kolham, who have dealt a Tangia blow on the neck of the deceased Hare Krishna Mohanto, and the evidence of PWs 2, 3, and 7 were the eyewitnesses to the occurrence. So also the doctor bracket with PW 14 conducted post-mortem examination is very clear about such assault, and the doctor has noticed one chop wound on the upper neck and to find the cause of death to be hemorrhagic shock resulting from such injury. It is submitted by the Land Council for the petitioner that in view of the nature of overtact attributed against the petitioner and absence of any chance of early hearing of the appeal in the near future, the bail application may be favorably considered. Land Council for the state placed the evidence of the eyewitnesses and submitted that the petitioner also chased the deceased along with the appellants Kulho alias Kwansu and Sona alias Kwansu. Considering the submission made by the Land Council for the respective parties, nature of evidence on record, since the specific rule has been attributed against the appellant Kulho alias Kamal Lochan Mohanto to have assaulted the deceased on his neck with a tangia. And further taking into account the fact that the petitioner was on bail during trial, we are inclined to release the petitioner on bail. से जो CRL number 717 date of custody केते same date ये भी bail ले थिला so bail granted same order तापरे जो CRL number 595 of 2024
कौन 1 week after कौन
I am appearing on this case.
এটা তো আমি রিজেক্ট করি 1 week after
No, 1 week after.
the land council for the appellant 6 for an adjournment all right
how do you time this and 1 week
the
take more time
2 weeks after next
Item 12.
Minor to I filed one IA number 22 of 25.
Mr. Panda, please file that. Yes.
Yeah, please. Item 12 minor, I filed one IA number 22 of 25 for appellant interim bailment.
On ground rate.
ତାର ଦୁଇ ଜଣ ପିଲା ଅଛନ୍ତି ସ୍କୁଲ ଗୋଇଂ ଚିଲଡ୍ରେନ୍ ମାନଙ୍କର ପାଠ ପଢା ଆଉ ଟିକେ ତାଙ୍କର ବୁଡିଂ ର ପ୍ରୋବ୍ଲେମ ହଉଛି ସେ ମାନେ ଛୋଟ ପିଲା ବୁଡିଂ ମା ତାଙ୍କର ଅଛି ଯେ ସେ ଏଜ ଓଲ୍ଡ ସେ ଆଉ
ନାଇଁ ଆପଣ କେତେ ବର୍ଷ ରହିଲେଣି
କଷ୍ଟଡି ସିନ୍ସ 798
2018
minor.
Direct evidence ଅଛି
Circumstantial evidence.
କଣ circumstantial
Circumstantial is only that my lord dead body was buried before that relatives.
The petitioner is the husband of the deceased.
of petitioner the husband
Of the deceased.
They have killed the deceased and without informing the family
दे
member,
माने के केतटा
the
appellant
petitioner or his mother
Mother-in-law and the family members.
before arrival of the family member of the
they buried
for which
one relation of the deceased on he had been to the house of the present petitioner to look after the deceased mother. He found that the deceased died. That relative informed the family member of the deceased. Before arrival of the family member of the deceased, they have buried the dead. And police seized some bone and from the
no it's all right that the deceased died and it was buried but how do you say that it is a case under 302 201 it may be there so for that what she has seen that lady has seen the dead
body of the deceased in the house of the present petitioner.
dead body ମାନେ ଖାଲି ସେମିତି କହିଲେ 302 ଟା ହେଇଛି ମାନେ ଆପଣଙ୍କୁ କିଛି ତ ପୁଣି ଆଣିବାକୁ ପଡିବ ନା ଆପଣଙ୍କୁ
Here my the present petitioner is the husband. He has
what he has stated how the deceased died 313 statement ରେ କଣ no suppose his wife died out of some diseases let us say take for an example somehow or other he just buried the dead body so can it be a case under 302 201
previously he was torturing
ଆପଣଙ୍କୁ ଆଣିବାକୁ ପଡିବ ଯେ କିଛି ମ୍ୟାଟେରିଆଲ ଆଣି ଦେଖିବାକୁ ପଡିବ ଯେ 302 ରେ ତ ଡେଡ୍ ବଡି ହେଇଗଲା ତେଣୁ ପୋଷ୍ଟମର୍ଟମ ରିପୋର୍ଟ ନାହିଁ
106 ରେ
ତ ସେଇଥିପାଇଁ ସେମାନେ କଣ କହୁଛନ୍ତି ତା ସ୍ତ୍ରୀ ମଲା କେମିତି ସେ ବିଷୟରେ କଣ ନା ଖାଲି ମିଛ କଥା ଲତାର ଏଇପରା ସେ କହୁଛି ଲତାର ଦେହ ଭଲ ନଥିବାରୁ ସେ ମରିଗଲା କିଏ ତାକୁ ଦେଖିଥିଲା ତା ଡେଡ୍ ବଡି ଟାକୁ କିଏ ଦେଖିଛି
PW4 first sorry
ରୁହନ୍ତୁ PW4
ଏ ତାରିଣୀ
He was on bail.
ଯୋଉଟା ବେଲ୍ ରେ ପଳେଇଛନ୍ତି
Premature release order ହେଇଗଲା ପରେ dispose of କରିଦେଲେ ଗଲା କାମ।
ହଁ ଯୋଉଟା ଭିତରେ ଅଛନ୍ତି ସେଇଟା କେମିତି ଜାଣିବେ ଆମେ ତାଙ୍କୁ କହିବାକୁ ପଡିବ ତାଙ୍କ ଫାଇଲରେ ଥିବ ବେଲ୍
ପୁଣା ଗୋଟେ ଦେଖି ତମ ମଗେଇ
ଯୋଉଟା ବେଲ୍ ଆଲାଉ ହେଇନି ସେଟା ରିପୋର୍ଟ ମାଗି ଦିଅନ୍ତୁ ନିଜେ ନିଜେ।
Emma,
18 ଯାଏଁ ଆଟଲିଷ୍ଟ
just serial number 686 of
ନାଇଁ ନାଇଁ
serial number 99 of 2007. Is there any order to that effect?
ଥିଲା
Uh,
ହଁ
the-
13-1
As per the order dated 13/1/2025, the Land Council for the state has produced the report dated 4/2/2025 of the Superintendent District Jail Bhawanipatna, wherein it is mentioned that the appellant has been released prematurely on 11/10/2019. The report is disposed of. Yes.
ଆଉ ଅଛି ସେମିତି
ଆଉ ଅଛି ଏ 2008 ର ଯୋଉଟା ନା ଅର୍ଡର କରିଦବ ଏଗୁଡା ନେଇ ଆସିବେ ସବୁ
ସେଟାରେ ସେ ବେଲ୍ ଅଛି।
ବେଲ୍ ରେ ଥିଲା ତ
ଏଇଟା ବେଲ୍ ଅଛି
ବେଲ୍ ରେ ଥିଲା ଆଉ କଣ ଇନଷ୍ଟ୍ରକ୍ସନ ଆଣିବେ
ନାଇଁ ନାଇଁ 14
ନେକ୍ସଟ
8 of 2008 on behalf of Jambeshwar Prati kindly taken up to move. He was on bail.
he be
he
bail
was on no question of whether he was on bail during trial or not. Question is that whether he has been released
On bail
prematurely because এই appeal ରେ ତାକୁ bail ଦିଆ ହେଇନି
ଦିଆ ହେଇଛି 8 of 2008 ରେ ଦିଆ ହେଇଛି
କୋଉ order ରେ
ଏଇଟା 19/4/2019 ରେ ବେଲ୍ ଯାଇଥିଲେ କିନ୍ତୁ ତାପରେ
ଲିଷ୍ଟ
ନାଇଁ ତାପରେ ସେ କେବେ ସରେଣ୍ଡର କଲେ
he was released completely not it so
ହଁ
এটা
19/4/19
ନାଇଁ ଏଇଟା ହେଇନଥିବ now এইটা କୁହନ୍ତୁ ମିଷ୍ଟର ରାଜେଶ ତ୍ରିପାଠୀଙ୍କର ଯୋଉ ମ୍ୟାଟରଟା ଏଟା ଯାଇଛି ନା ଅଛି ବେଲରେ we have to take it ନାଇଁ କୋଉଟା accused ନେଇ ଆସନ୍ତୁ ଏଇ ଯୋଉ ଏକ ଆପଣ 14-15 ବି ନେଇ ଆସନ୍ତୁ କାରଣ ଏଇ ସବୁ ପ୍ରାୟ ହେଇଗଲାଣି 16 ନମ୍ବରଟା ମଧ୍ୟ
ଆଇଟମ 14
14, 15, 16 ହେଲା ଏ ତିନିଟା ମ୍ୟାଟର ଆପଣ status of the accused ନେଇ ଆସନ୍ତୁ concerned jails through the concerned jail superintendent ହେଲା more specifically ପଚାର ଦେବେ କିଛି premature release order ହେଇଛି କି ନାହିଁ ଯଦି ହେଇଥିବ ସେ intimation ଦେଇଦେବେ ହେଲା ଆଉ ଯଦି ନାହିଁ ତ ନାହିଁ ଆଉ ଏଗୁଡାକରେ recent case ଗୁଡାକରେ ହେଇନଥିବ ଏଇଟା ବି
and we were hearing criminal appeal ଯୋଉଟାରେ premature release ହେଇଯାଏ usually letter ପଠେଇ ଦଉଥିଲେ ଏଇଠି ଆପଣ ଟିକେ instruction କରିଦଉନାହାନ୍ତି ପଠେଇଦେବେ pending appeal
pass the ତାର ଇଏଟା ଅଛି ଯେ one criminal appeal he was released prematurely no intimation was given to us it was argued and we passed the judgment also and after the pronouncement of the judgment when we passed the order confirming the life imprisonment sentence then the intimation came that he has been released premature so we passed the judgment that the appropriate government has power all these things but what is 49/2008
I have collected order from the order that
oh that is free type of it so better ହଉଛି ଆପଣଙ୍କର ଯୋଉ କନସର୍ନ ଜେଲ ସୁପରିଟେଣ୍ଡେଣ୍ଟ ମାନେ ଅଛନ୍ତି ସେ ଯୋଉ କେସରେ ପ୍ରିମାଚ୍ୟୁର ରିଲିଜ କରୁଛନ୍ତି ସରକାର କରୁଛନ୍ତି ତାର ଯଦି ଅପିଲ ପେଣ୍ଡିଂ ଅଛି ଆଇଦର ଇନ୍ CRL ହଉ ବା JCRL ହଉ से इंटीमेशन गुड़ाक एजी ऑफिस को दिया जीवो नंबर 1 हाईकोर्ट को मध्य दिया है सो दैट इटा रेकॉर्ड रे शामिल ही गले जितेबेले भी मैटर लिस्ट रे आसीबो हियरिंग पई the court can peruse it and pass necessary order हैला it should be eta apanଙ୍କର
officer the
ha AG ko
AG should implement to the DG prisoner so that it can
right
communicate to all
AG eta lekhibe DG prisons को DG prisons से instruction टा pass करिवे हैला
that will
जो
facilitate
जो pending appeals अछि जोगुड़ा को माने जेल रे अछंती जो पेंडिंग ये रे माने आपनकर प्री मैच्योर रिलीज हेई जाइछि माने ये रु से केस गुड़ा को आपण इंटीमेशन गोटे पीरियड दे देबे हैला कारण कस्टडी गला माने आपनकर पेंडिंग अपील रो लिस्ट थिवो
आज्ञा
हैला से जेसीआर ले हो ये हो एडा सब लिस्ट थिवो ता परे मन करंतु प्री मैच्योर रिलीज हेई जाइछि किंतु अपील पेंडिंग अछि तो से गुड़ा पर इंटीमेशन शुड बी प्रोवाइडेड टू द एजी ऑफिस also to the court हैला
Mr. Tripathi, your case is a case of double murder.
Yes,
He gave poison.
so let this report come because you might have been released who knows so
double
तार केतोडा कैटेगरी अछि
double murder le 25 वर्ष
नै तार अछि 25 वर्ष हे गेले से
double murder
छाडू नांदी पर
25 वर्ष परे छडा
आउ गोटे भी अछि बोले मैं आई थिंक इफ आई एम नॉट मिस्टेकन छोटो छुआ के मारले भी दो नांदी बिलो 12 इयर्स ना गण
नै से जो 22 मसिया रे जो तांकर गोटे स्कीम करिसेन हां तो स्कीम ता आनिछन स्कीम रो स्कीम रे हां सेटा दियो स्कीम रे केतोडा एक्सक्लूड करछन ऑफेंस आई डू नॉट नो दैट इन 25 वर्ष परे ineligibility of the premature release. The following category of the convicted prisoners undergoing life sentence may not be considered eligible for premature release. Rape, docaity, terrorist crimes. Convicted of organized murder in premeditated manner. Professional murders. Convicts who commit murder involved in smuggling operation, having committed murder, a public servant on duty. Certain category of convicted prisoners undergoing life sentence would be entitled to consider for premature release only after undergoing imprisonment of 20 years, including remission. The period of incarceration, inclusive of remission, even in such cases, should not exceed 25 years. Following categories are mentioned in this connection by way of illustration and are not to be taken as exhausting list of such categories. Convicts who have imprisonment for life, murder, to heinous cases such as murder with rape, murder with dacoity, murder involving offense of so and so, murder of a child below 14 years of age, multiple murders, murder committed after conviction while inside jail, murder during parole, murder in a terrorist incident, murder in smuggling operation, murder of public servant on duty, gangsters, contact killers, so and so, so and so. Convicts whose death sentence has been commuted to life imprisonment. All other convicted so and so, not covered on so and so, undergoing sentence of would be entitled. So each ଜିନିଷ ଗୁଡାକ exclude କରିଦେଲା. এই जो लाइन टा ଆଉ ତାପରେ जो लाइन टा needs clarification. The period of incarceration inclusive of remission even in such cases should not exceed 25 years. Does it mean that even after 25 years, in those cases also, they are to be released prematurely, or their case can be considered for premature release?
Last year, say
ଏଇଥିରୁ ଜଣା ପଡୁଛି following is the line, very important. ଜେନେରାଲ ହେଲା 14 ବର୍ଷ, କେତେ ଗୁଡା କେସ୍ କଲେ 20 ବର୍ଷ, କିନ୍ତୁ ଆଉ କେତେ ଗୁଡାକ କହିଲେ otherwise 25 ବର୍ଷ, କିନ୍ତୁ no circumstance ରେ 25 ବର୍ଷକୁ exceed କରିବ, ସେଇଗୁଡାକ ଟିକେ ତାପରେ
such cases.
Certain categories of cases and convict undergoing so and so be entitled to be considered for premature release only after undergoing ତାଙ୍କ case 20 ବର୍ଷ ହେଲା ପରେ consider କୁ ଯିବ.
But ସେଇ category 25 years ପରେ
the period of incarceration
consider ଯୋଉଟା ମନା ହେଇଛି otherwise ସେ ବୋଧେ 25 ବର୍ଷ ପରେ ସେମାନେ ବି ରହିବେନି ନା କଣ ମିଷ୍ଟର ପଣ୍ଡା ଯାହା ବୁଝା ପଡୁଛି
ଦେଖିଦେବେ ଏ କପିଟା ନିଅନ୍ତୁ ଆପଣ ନିଜେ ବି ଆଉ ଇନଷ୍ଟ୍ରକ୍ସନ ବି ନେଇଯାଅ କାରଣ ଯାହା ଜଣା ପଡୁଛି ଗୋଟେ ଲାଇନ ତ ପୁରେଇଛନ୍ତି କୌଣସି କେସରେ ମାନେ ରେମିସନ ମିଶେଇକିନି ଯଦି 25 ବର୍ଷ ହେଇଯିବ ତାହେଲେ ତାଙ୍କ କେସ୍
ପ୍ରୋବ୍ଲେମ ଏଟା 2010 ତାପରେ ନୂଆଟେ
ନାଇଁ ନାଇଁ
2022
କଣ 2022 ନାଇଁ 2022 ଦେଖନ୍ତୁ ଏଇଟା 2022 ନୋଟିଫିକେସନ ଟା କୋଡିଟା ଏଇଟା ହେଲା
ପଢିଲୁ
ନାଇଁ ଯୋଉଟା ଆମେଣ୍ଡମେଣ୍ଟ ହେଇଛି
ଆମେ ଯୋଉଟା ପଢିଲୁ 2010
ଏଇଟା ହଉଛି 2023 ର
କଣ ଅଛି ଦେଖିଲ ଏଇଟା
ସେଇଟା ହୁଏ
ଦେଲେ ଲଗେଇବେ
ଓଡିଶାରେ ଜଜ୍ ଥିଲେ ବୋଲି
ପକେଇଦେବେ ଖୋଲିକି ଦେବେ ଯୋଉଟା ଆମେ ପଢିଲୁ that was 2010 ତାପରେ 2023 ରେ ଗୋଟେ ଆସିଛି ହେଲା ଏଟା ତ ହେଲା ପ୍ରୋସିଡିୟର ପ୍ରୋସିଡିୟର କେମିତି ହବ କଣ ହବ
the cases of the case to the guidelines of 2020-22
ସବୁ ଏଇଠୁ
senior saying that both are below Odisha, that's a district of judgment has come up.
2022 ଆଉ 23 ର ଟିକେ ଦେଖିବାର ପଡିବ। ଏଇଟା ପ୍ରାୟ ରିପିଟ୍ ହେଇଛି ନାଇଁ?
Eligible.
ହେଇଯିବ 20 years 20 years ସେଇଟା ଯାହା ଥିଲା ସେଇଆ
Be eligible କଲେ
ଏଗୁଡା ସବୁ ତା ଦେହରେ ତାମାନେ
ଏଇଟା
other than those
ତାପରେ ଆସୁଛି
ନା
80 ଆସିବ provided that the categories of life can be mentioned in clause A and B may be placed for consideration. It's clear.
maybe placed
So now it's very clear that ସେଇ ଯୋଉ type ର ଇଏ ତାଙ୍କୁ 20 ବର୍ଷ minimum ରହିବାକୁ ପଡିବ କିନ୍ତୁ କୌଣସି ପରିସ୍ଥିତିରେ 25 ବର୍ଷରୁ ଆପଣ ଇଏ କରିପାରିବେ that is provided the categories of life convicts mentioned in clause A2 ଯୋଉଟା ଆପଣ ଅଛି ନା 22 ର ଅଛି ତ 22 ର
22 ର ଇଏର ସେ ଅଛି
22 ର ଇଏ
20 ବର୍ଷ ପରେ ହବ except A to E but A to E ବି 25 ବର୍ଷ ପରେ they can be considered.
ଦବ କି ନ ଦବ that's a different matter. Their case can be considered for premature release.
ଇଏ ତ ଯିବ ଫିମେଲ ଦି ତିନିଟା ଅଛନ୍ତି ସେ ପଳେଇଥିବେ ନା 60 ବର୍ଷ ସେ ବୋଧେ ଯିବାଣି ଆଉ
ତାଙ୍କ ପାଇଁ ଆମର ଆଜି ଆମେ କରୁଛୁ ଆମର 14, 15, 16 ପାଇଁ ଅର୍ଡର କରୁଛୁ ହେଲା ବଟ୍ ମୁଁ କହୁଛି ବହୁତ ପୁରୁଣା ଜେଲ କ୍ରିମିନାଲ ଅପିଲ ସବୁ ପେଣ୍ଡିଂ ହେଇ ରହିଛି ଡିଭିଜନ ବେଞ୍ଚ ତାକୁ ଗୋଟେ ଲିଷ୍ଟିଂ ସେ କରିଦଉ ସବୁଥିରେ ଅର୍ଡର ଗୋଟେ ଜେନେରାଲ criminal jail criminal appeals of 2007, 8 are also pending. So let it be listed so that 8 type of order କରିଦେଲେ ଆପଣ ଗୋଟେ report ନେଇ ଆସିବେ ଯେ କେତେ ତା ଦେହରୁ ଯାଇଛନ୍ତି premature release ଯାଇଛନ୍ତି ନା ନାହିଁ ହେଲା ଦେଖି ଦଉଛି କେତେ ରହିଛି ବୋଲି report
judicial order that can be communicated to government to the DG prison so that it can be conveyed to all.
Judicial order means standing order.
We just want that you are to bring a report whether they have been released prematurely or not. Now, have you got a copy of this one? It is nahi apan gote copy kar rakhon. This is a very important thing.
See dele amku bode apan dele to aw amku debe
eta diyantu and a copy also to be Mr. Panda also karan adhiru jaha padhilu je 25 ବର୍ଷ ପରେ ଯେ କୌଣସି କେସ୍ ରେ ମଧ୍ୟ it can be considered. It depends upon you whether you release or not. That's a different thing. କିନ୍ତୁ ସେଇ ଯୋଉ କେସ୍ ଗୁଡାକରେ 25 ବର୍ଷ ପୂର୍ବରୁ କନସିଡର ହିଁ ହେଇପନି ଯୋଉଟା ରେପ୍ ୱିଥ ମର୍ଡର ହେଲା ଏଗୁଡା ମଲ୍ଟିପୁଲ ମର୍ଡର ସେଗୁଡା 25 ବର୍ଷ ପୂର୍ବରୁ
ବଟ୍ ସେଇଗୁଡା ଏବେ କହୁଛନ୍ତି 25 ବର୍ଷ ପରେ can be considered
then
25 ବର୍ଷ no consider
ସେଇଗୁଡା ହଉଛି ମେନ୍ ତେଣୁ
ଆପଣଙ୍କ ଲାଗିଲାଣି ଲେଡି ଟା ପଳେଇଥାଇ ପାରେ ସେ ବୁଝିବାକୁ ପଡିବ
And status of the lady, whether it is alive or not.
ସେ ବି ଗୋଟେ କଥା
ତ ଏଇ ତିନିଟାରେ ଅର୍ଡର ଆଜି ହଉଛି ମୁଁ ଆମେ ଲିଷ୍ଟିଂ କରୁଛୁ 14, 15, 16 ବାକି ଯେତିକି ମ୍ୟାଟର ନିଜେ ଲେଖନ୍ତି ଏଗୁଡାକ ଆମେ ଜୁଡିସିଆଲ ଅର୍ଡର କରୁଛୁ ବିକଜ these are the appeals of 2008 and 10 ହେଲା ଆଉ ଏଗୁଡାକ ସବୁ 14 ପରେ ଅଛି ତ ଏଗୁଡା ଲାଟେଷ୍ଟ ଗୁଡା ଯଦି ଆପଣ ଜାଣିବାକୁ ଚାହୁଁଛନ୍ତି କଣ ଦେଇପାରନ୍ତି ବଟ୍ ୟୁ ଡୋଣ୍ଟ ଥିଙ୍କ ଦ୍ୟାଟ 2014, 15 ଅପିଲରେ ସେମାନେ ଏତେ ଶୀଘ୍ର କରିଥିବେ ବୋଲି
10 ବର୍ଷ ହେଲାଣି ଆଗରୁ ଆଉ 5 ବର୍ଷ ଥିବେ
14 ବର୍ଷ କେମିତି
ସରି 10 ବର୍ଷ ଜେଲ ହେଇଥିବ
ହଉ ହେଲା ଏଇ 14 ଯାଏଁ କରିଦଉଛି 17ଟା ବି ସେଇଆ କରିଦଉଛି ଅର୍ଡରଟା
17 in custody.
17 years ତାହେଲେ
Custody.
13
years.
ତାହେଲେ
Custody.
ଠିକ ଅଛି
ଏଟା ବୁଝି ଦେଇଛନ୍ତି
ଆଜ୍ଞା tomorrow
he's in custody ଆଉ ତାହେଲେ ଦରକାର ନାହିଁ ତ ଶୁଣ ତାହେଲେ ଏଇ 14, 15, 16
Ida jo burnt the wife and wife gave birth to a dead child.
90 days.
ନାଇଁ ଗୋଟେ ଛୁଆକୁ ଜନ୍ମ ଦେଲା before dying. ଡବଲ ମର୍ଡର ତା ଉପରେ ଦିଟା ଅଛନ୍ତି. ହଁ ସେ wife ଆଉ ଛୁଆ. ଏଇ ତିନିଟା ଯାକ ବୋଧେ ଡବଲ ମର୍ଡର. ଛୁଆକୁ ପଏଜନ କରିଦେଇଛନ୍ତି.
17th ରେ এই ଯୋଉ ଅର୍ଡରଟା ଆଜି ଆମେ କରୁଛୁ ଏଇ ଯୋଉ ମ୍ୟାଟର ତିନିଟା ମ୍ୟାଟର ଲିଷ୍ଟ ହବ 17 ତାରିଖରେ ତା ପୂର୍ବରୁ ଆପଣ ରିପୋର୍ଟ ନେଇ ଆସିବେ କନସର୍ନ ଜେଲ ଆଉ ଯଦି କୋଉ ଜେଲ ଜାଣିବାକୁ ଚାହୁଁଛନ୍ତି ତାହେଲେ ଆପଣ ଦେଖି ଦିଅନ୍ତୁ ବ୍ରିଫରେ ଅଛି ତ ଆଉ ତ କାଲି ଆପଣଙ୍କର ମ୍ୟାଟରଟା ଦିଆଯିବ ଫାଷ୍ଟ ମ୍ୟାଟର ତ ହେଲା
I have a friend.
Yes.
I have been engaged to appear in item 20,
20
but I'll not be available from tomorrow.
next week
Next week after the 12th.
ସେଠି କିଏ ଥିବେ ତାଙ୍କର ତ ହବ.